Good morning, everybody. Happy Super Friday here at TCF Live. You know it's going to be a good day because before I hit the Let's Go button, I'm sitting here tapping to the beat of the intro song. Let's have a great day today. We'll start it out in Miami. Mindy Glazer.
Good morning, Your Honor.
Good morning, sir. I'm waiting for Miss Prieto Sanchez. She's the interpreter. Good morning, ma'am. Your lawyer is here. You were arrested for organized scheme to defraud, fraudulent use of personal identification, unlawful use of a communications device, and grand theft.
Buenos días, señora. Ya se halla su abogado presente en la plataforma Zoom. Le reitero sus acusaciones que enfrenta es el haber confabulado organizadamente para defraudar o estafar, el haber utilizado fraudulentamente un método de identificación, el haber utilizado ilícitamente un método de comunicación y además hurto en mayor cuantía.
Your attorney is here. Good morning, Mr. Takashel. Any argument you have regarding probable cause?
Yeah, good morning, Your Honor. Arturo Takechel on behalf of Sailis Prieto. We surrendered her yesterday afternoon, Your Honor, to the lead detective in the case, and we're fully expecting her to appear before you. I would ask that Your Honor make a probable cause determination and set a reasonable bond, Judge.
Se presenta su abogado. Buenos días, su señoría. Soy Arturo Taquecher representando a Saily Prieto. Ayer la entregamos en la tarde al detective cabecilla de la investigación con la intención de que se presentase ante usted el día de hoy. Espero que hoy usted pueda determinar motivo fundado y imponga una fianza justa.
Ma'am, you are ordered to stay away from the alleged victim whose initials are MQ.
Señora, se le ordena estar alejada de la presunta víctima cuyas iniciales son MQ.
So contact with the victim either directly, indirectly, in person, in writing, by telephone or through third parties.
No puede tener contacto con la víctima de forma directa, ni indirecta, ni por teléfono, ni por escrito, ni a través de terceras partes.
And stay at least 500 feet away from the victim, their home, school, and place of employment at all times.
Tiene que estar a todo momento, como mínimo 500 pies alejada de la víctima, el hogar de la víctima, escuela a la que asista o centro de trabajo.
All right, so count one, there's probable cause, organized to defraud. I'll set that at 1,000. I don't know, what do you want, 1,500 on that?
I do a total bond 5,000, Judge.
Oh, no, it's not gonna be that low.
Okay.
$1,500 bond count one, $2,500 bond count two. Count three, unlawful use of a communications device is $2,500. And count four, grand theft will be $1,000. So the total bond is $7,500.
Your Honor, I have to ask for Nivea.
No, Nebia, she's free to bond.
No, Nebia, yeah.
Muy bien, entonces vamos a establecer las fianzas con motivo fundado determinado. La acusación número 1 de la confabulación para estafar o defraudar van a ser $1,500 de fianza. Número 2, el uso ilícito de un método de identificación, $2,500 de fianza. Número 3, el uso ilícito de un método de comunicación, $2,500. Y en el número 4 van a ser $1,000 por el hurto en mayor cuantía. Se confirma que no hay requerimiento Nevia. En un total de $7,500 de fianza.
I thank you.
Thank you, Your Honor. Have a great day.
Corrections on page 15. Do you have Miguel Gomez?
Your Honor, Mr. Gomez refused court today.
You want to waive his presence? Can you do me a favor? Yes, state your name, Mr. Gomez.
Adolfo Gil on his behalf. Your Honor, we're asking for a standard
For what?
standard bond.
Okay, and you're waiving.
These are added charges, Your Honor.
All right.
The golf carts.
Yeah.
Oh, more of the golf. Okay.
I think the state previously says something about $1,000 each.
1 minute. I'll find probable cause and let me see. What do you want me to set? 2,500 count one, 1,000 count two. All right.
Thank you. Have a nice day.
Joanna Barrera Delgado, page 2. Does she have an immigration hold?
Yes, Your Honor, she does.
Okay. Good morning, ma'am.
Spanish interpreter, please.
Good morning, ma'am. You were arrested for a case from December 11th of 2025. The charges are aggravated child abuse and child neglect and tampering with a victim.
Buenos días, señora. Usted fue arrestada por un caso que data del 11 de diciembre de 2025, donde las acusaciones que constan son abuso a menor con agravantes, negligencia de menores y además tratar de influenciar a una víctima.
I am appointing the public defender's office for you.
Le asigno el abogado de oficio para que les represente.
Also, you have an immigration hold.
Y además sepa que tiene retención por parte de las autoridades migratorias.
I believe there's probable cause for all of the charges.
Considero que tenemos motivo fundado para todas estas acusaciones.
So Judge, it would be a first degree felony rather than a second. I believe the officer chose the wrong charge.
Su señoría, esto sería un delito mayor en primer grado en vez de en segundo grado. Yo considero que el agente eligió la acusación equivocada.
So there's probable cause for aggravated child abuse causing great bodily harm, which is a first degree felony.
Entonces, la primera acusación sería abuso o maltrato a menor con agravantes causándole grandes daños corporales, que es un delito mayor en primer grado.
Is that a first thing? Is it, or she's not using a weapon?
So I
Bueno,
believe
pero ella
it's
no
a
está
first.
usando un arma.
I'll pull the statute, we can confirm. But if you look at the way it was booked, it says /90. So I think they're charging it before a statutory change was made.
Yo puedo sacar los estatutos y podemos confirmar, miramos, pero si puede mirar donde
Well, alrighty then. Looks like the feed has been disabled.
please put your hand down. Ms. Adams, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Okay, everybody, we're back. Apologies for that. We had an internet blip here, so we had to move to the backup. But we're up and running. Sorry about that. We're with Judge Meineke now in Michigan.
A charge of larceny, 200 to 1,000. That's a misdemeanor charge, carrying with it a maximum possible fine of $2,000 plus costs and up to 1 year in the Owen County Jail, all at this court's discretion. These are maximums, all right? Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses that came in against you. You'd have the right to have the court subpoena or bring in witnesses on your behalf. You'd have the right to testify if you wanted to, remain. You have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Ms. Adams, do you understand that once you enter a plea, you give up all those rights that I just said that you have in a trial?
Yes, sir.
Once you plead guilty, there won't be a trial. You understand that?
Yes.
Has anybody promised you or threatened you in any way other than the reduction of charge in order to get you to plead?
No, sir.
Is it your own choice to do this?
Yes, sir.
Okay. So it's my understanding, Mr. Spencer, that the original offense involved taking of a wallet and contents, and really the value was below $200, but because it was in a building, it was larceny in a building, and that made it a felony. Is that right, Mr. Spencer?
That's correct, Your Honor.
Okay. So Ms. Adams, this is the way this is going to work. I'm going to ask you questions, and it's going to sound like I'm taking a plea on the felony. I'm not. The law allows me to take a plea on the original facts and then apply them to a reduced charge, because technically you didn't steal between $200 to $1,000. But the benefit of that charge is it's a 1 year misdemeanor rather than a felony. Okay? So I'm going to ask you a couple questions, and then I'm going to accept the plea on the reduced charge. Does that make sense, ma'am?
Yes, sir.
Ms. Isaac, is that okay with you? Does that make sense?
Yes, Your Honor. For clarification purposes, it's 200 to 1,000. Is that correct? The 1 year misdemeanor. Yes.
200 to, if I didn't say that correctly, it's 200 to 1,000. But I thought that the amount stolen was actually $40.
No, Your Honor. Respectfully, it's $1,075, and we will stipulate to that amount.
Oh my goodness, I misread. I thought it said a wallet, and was there more, I guess, that I didn't know?
Yeah, Your Honor, if I can help with this one, it was the original state report indicated that there was only $40 taken from the wallet. However, the victim indicated that it was actually $350, I believe, and then there was the value.
Okay.
And I think the value of the wallet itself is where the victim was most concerned. She wanted.
There we go. So then I can just ask that it's over $200 and we'll be fine. Okay.
Thank you.
So Ms. Adams, directing your attention to, let's see here, August 7th of last year, 2025. Did you take a wallet and money valued at over $200 with the intent to permanently deprive the owner of that property?
Yes, sir.
Okay. All right. So I think that qualifies. Mr. Spencer, are you satisfied?
People are satisfied, Your Honor.
Ms. Isak?
Yes, Your Honor. Defense is satisfied. Thank you.
All right. I too am satisfied. The plea is knowing, voluntary, and accurate. I'll accept the same. Again, I didn't have the full police report, and so I wanted to make sure that we took an accurate plea. So the original larceny charge is dismissed. I'll accept the plea on the larceny, 200 to 1,000. And I will order a pre-sentence investigation. So, Ms. Adams, what's going to happen from here is my staff's going to get in touch with you and your attorney, and they'll do an interview with you. They'll set up an interview, and that'll be on Zoom, like you and I are talking right now. And then we'll also
Okay.
set up a sentencing date. That sentencing date will be in person with me and your attorney, okay?
Okay.
All right. Anything else for the record, Mr. Spencer?
And from the people, Your Honor.
Yes, Your Honor,
Ms.
if I
Ezek?
may. Yes, Your Honor,
Yes.
thank you. My client has the full restitution amount. Will the court allow her to come in and pay that to the 44th District Court where it could then be transferred to the complainant in this case?
Yes, she
I
can
just-
come in and take care of that.
Today, is that okay?
Yeah, that's even better if it's today.
All right, thank you. Nothing else.
All right, good to see you. And Ms. Adams, we'll see you for sentencing. Good luck.
Have a good day.
Okay.
Once again, everybody, good morning. Welcome to TCF Live. Apologies again for the blip we had a little while ago, but this is why we have two ISPs running into the bunker here at TCF, is so when one decides that it wants to not play nice, we can flip to the other and keep going. Let's change it up. Let's go down to Texas. We'll say good morning to Judge Stevens.
Pardon, Judge.
Yes, ma'am. Okay, you first to handle, this is Christopher Harris.
Yes, Your Honor.
And
I filed a motion requesting a bond. He's on a deferred educated probation.
what is this?
That's a new,
This file.
that's a new case.
I thought this looks like a new case.
No, this is the MTRP.
I know it is.
Yeah.
But where's the cover? So, I mean, where's the normal
Judge,
jacket?
remember the district clerk's office is no longer providing us
It's mine.
files, so we had to purchase our own files.
So
And those are the most, those are very expensive, Judge.
They're what?
They're very expensive, and we didn't have money.
And the defense attorneys pay for it. They're very expensive. They're very well.
These were the ones we could afford, Judge.
Spending on this. Well, we're gonna write on, then what we'll do is we'll write on it. Have it on. Okay. I'm gonna do that. But that's the first time I've seen that one.
Yeah.
That's the first time.
Applying for just, outside of the budget.
I've got 25 CR 75, which is a motion to revoke probation. And are you Christopher Harris?
Yes, sir.
Uh-huh. You were placed on probation May 29th. Is that right?
Yes, Your Honor.
I'm speaking.
Yes, sir.
And then this alleges that 5 months later, you've committed another crime according to this indictment. Is that right?
Yes, Your Honor.
Is that right?
Yes,
That's
sir.
what you understand? Okay. Plus, it looks like, let's see, evading arrest, terroristic threat, burglary of a habitation, failing to perform community service, being at a location after the curfew, failing to pay assessed fees. What else can go wrong? And then this is a new third degree felony. So you're on probation. This court allowed you deferred or unadjudicated probation on May 29th. And just a few months later, here we are again. And what are you asking?
Your Honor, I'm asking that a bond be set on it's our understanding the terroristic threat and the burglary, our understanding is that we don't anticipate those cases to be filed because he was residing at the home. But we will need to address the evading at a later date, but we are requesting a bond.
It's probable cause affidavit. Problem? What were you saying about he lives where?
He was residing at the home where they're alleging the burglary.
Which is where?
With his girlfriend.
Which is what?
Yeah.
I'm not familiar with the number, but it's a big base.
You don't even know the number.
It just moved there.
Yeah, I thought you were living at LaSalle.
Yeah, I live on 46 LaSalle, but we.
Okay, how many places do you live at?
So we'll spend nights at her house and she'll spend nights at my house. So when we was together.
Does a probation know he was moving around? He had different residents? You didn't even know that? Thanks. You're on my watch. And you're doing your own thing. You're on your rules. You do it the way you want to do. You're under the directions of this court. Do you understand that? Speak.
Yes, sir.
Thank you. You're looking at 20 years in prison. You want to flirt with that by acting irresponsibly?
So.
Yeah, you do. So we're judged by the actions, not the talk. Anybody can talk. It's the actions, our actions, what speak loudly.
Yeah.
Oh, there are six violations here alleged. What state say?
Your Honor, he's on there for aggravated assault with a deadly weapon.
Mhm.
He wasn't on there long, so we would ask the court to, if it allows a bond to make it sufficiently high, to request $250,000.
And Your Honor, obviously that we were asking it be lower than that. Mr. Harris is employed with the McDermott plan and Sabine Pass. And if there would be any conditions as far as any monitoring that the court would need, and we would ask that that be set, but
All right, here's what we're going to do. It's going to be $100,000. He's going to be, he can't have any contact with the complainant. He is going to have a GPS device, so I know where he is at all time. He can't leave his house, which is not going to be at this location. You're not going to stay at this location on Alabama. You understand?
Sabine Pass.
Is it Sabine Pass?
Yes.
Planting locations of call to Alabama is where they located his location, where he was.
Which report are you reading, John?
Probable cause affidavit.
Which one? For the
This is
evasion?
the one. This is the one that is dated for. I'm just looking at it for his address. This is the one that was dated for the original case that he was put on probation for.
The address in which the burglary was related was 2781 Sabine Pass Avenue.
You can't stay there. then we understood that you were living at LaSalle. Because that's where you're.
Well, that's my experience.
In fact, this is what's ironic is the bondsman that posted your bond on 11/17, November 7th, the day after this, states your principal address is 460 LaSalle.
Yes, sir. Yes, sir.
Okay, that's where it better be. Because this was something sent to this court for us to rely on that's under oath.
Yeah.
So it's $100,000. You must stay at home. You can only go to and from work in the most direct route possible, to and from medical in the most direct route possible, and to and from food, acquiring food. You have no contact with the person involved in this allegation of November 16th. And we will have a hearing as soon as possible on this. When can y'all be ready?
Within probably 2 weeks, Your Honor.
I'll give you 3 weeks.
Yes, sir.
We're going to have a hearing on this in 3 weeks.
Okay.
And court will note here, Huston.
You have your right thumb print, right thumb, south. Yeah. You can, it needs to be a little darker, I'm seeing it. Okay.
Concerned about this allegation of a terroristic threat. That was alleged in the motion to revoke probation.
We weren't aware of any, because he was never in terrorist threat. I wasn't aware.
Yeah. You want to talk about it.
It's gotta be our total follow much.
So they've alleged it, right?
What's the weather here?
On the same event. That's
Respectful. Registered on the radio. Anything else? That'll have the one number had to be figured. Chill.
terroristic threat.
We're not aware.
We don't have any,
We don't file the motion.
It
says it in there.
shouldn't be in there, Your Honor.
Fine.
Yeah, we don't have that on there. I'll abandon that. That's what we have is the evading with a vehicle.
The probable cause affidavit for the underlying offense that he was placed on probation for. This is an event that happened last December a year ago. And that's what somebody must have placed in the motion. Because it is terrorism. It is stating that he had a gun, had two bodies already. And he had pointed a gun at the victim's head. And all right. Set this for hearing in 3 weeks.
Okay.
Okay. Yeah, that sounds on the motion to revoke. Tammy Judy's. What are we doing? Where's Tammy Judy? She's coming. What are we doing on this? This one's. No, Fisher cut bait, you know what I mean?
Yes, sir. I don't anticipate, we're trying to work something out on it. Ms. Janice has some pretty serious health problems, which of course, probably a legitimate issue. I know the court. I guess you could say we're looking for a little mercy. I don't know.
What are our health problems?
What are your health problems? Well, COPD, so whatever.
Broken hips.
She broke his hip while else.
Oh, you must have, what?
But I was gonna get a letter. She's going to the doctor the 19th.
Yeah.
You know, get information, a letter from him. I don't know if that's gonna affect things. It's the ability to maybe about. I discussed with Mr. Boyd.
What was the test result on this? We
Thank you.
never get it. We just get a probable cause, and that's the last thing.
Yeah.
And then the indictment shows up, and with her 4 prior convictions.
0.012, Your Honor, and this 0.009. This is
He's under on one.
No, she wasn't.
009.
0.09. 009.
That's right to say. It's all right. That's right. But it was low, relatively speaking.
And she also had that's the thing that she was under the limit on actually both, right? Because she was positive for codeine, 32 anagram per milliliter. So it was that was.
Okay, well, what are we gonna do?
It'll,
Okay. Look at the lady. Look at the
Yeah.
lady.
yeah,
She was stopped driving a 4,000-pound missile around town. Look at her.
I know.
What, intoxicated. My God. Have you been disabled for a long time or just since this event?
This that man.
Oh, before then you were in perfect health?
No, it wasn't perfect.
I know better. We know. I know what the situation. I know what your situation is. I just want to hear it from you so you don't fib to me.
No, I didn't.
No, you've been struggling for a while.
Yeah.
But is this a vehicle is a 4,000-pound missile,
Yeah.
and you were intoxicated, man. You can barely walk up here to get to this courtroom. You can barely do that, and there you are. I mean, you're struggling, which all comes that comes to all of us sooner or later. But we're talking about safety in operating a motor vehicle. My gosh.
I'm talking with Mr. Boyd. One of the considerations is to surrender a driver and sell her car. And it's not.
When is that going to be something more than a consideration? What are y'all going to do? She's looking at 10 years in prison.
I know.
Serious. What's this is, this event is well over 2 years old. We got to move forward.
Yeah.
One way or the other. So
Well, for some reason, because of the blood test or something, that took well over a year.
Well, I think they did the breath test immediately, but they were waiting on the lab
verification
from the other.
that must have gone through Greenland or something. So what are we going to do? Right. That's what it is. You want to play the Jeopardy theme?
No, probably, maybe.
Don't sing. Don't sing. Not those. Go ahead. You're not driving right now, are you?
No, sir.
Well, we're at this time.
Possibly enter into a plea bargain with a cap, and then
When will we do that? When do you want to do
If I could have.
That's 3 weeks. 3 weeks good?
That's pretty short, but if I could have.
Oh, she's.
Yeah.
This happened over 2 years ago.
Well,
And she was in, yeah. She was arrested, October 19th of 23.
That test didn't come back till late.
That doesn't matter.
Yeah.
When the event happened.
And just.
We really need to move one way or the other to the safety of herself and others. But this is. She already has, this is true. She already has 2 felony convictions for DWIs, right?
Yes, Your Honor. She's actually, there are 2 DWI thirds as well. And I think she was sentenced to 5 years on one of those previously. On a motion to revoke.
So I think one of them's taken into consideration on motion to revoke.
That doesn't make it sound any better. And there's 4 total DWI convictions that I have here. 2 of those are felonies. And then now here's the 3rd felony.
Yeah.
Number one, you can't operate a motor vehicle at all. Do you understand? So at all. Until such time we can resolve this safely for all of us.
Yeah.
Pick up the phone. And Bruce's wallet and his shoes. Let me back away. Frank,
Sorry.
4 weeks.
4 weeks.
Set it for 4 weeks. Okay. Set it for 4 weeks. Thank you. Jacoby Bandy. Jacob Bandy.
Well, he sounds kind of cool.
If we could come back on 6 weeks, Judge, this is one I'm going to talk to Keith about. I'm still planning. Thank you. I'm gonna go see Keith about this judge. I think we can, we might be able to get him the control of the program.
I never get these. What was the test done? I never get results of tests. They never make it in here.
Did you blow or you get blown? They haven't had any blood. Here's a.
Report date says 10/15 of 24, Judge.
Well, what I'm saying, it's not in my file. What's the, what?
What?
108.
So I think we'll get this one resolved. I'd say you go visit with Keith and.
And I have it if you want to look at this one, Judge.
Who was the child? Was it your child?
No, it was my brother's now wife's son. She's a Beaumont PD. I was prior law enforcement at that time too.
Okay, how old was the child?
I have no idea. That was the first time I met him, and I was only
How old do they look?
8.
Maybe. Okay, that's not what you said.
6 weeks.
You guys. All right. Cody Half.
Over here, please.
You can get a resetting, sir, right over there. And I guess you've got conditions of bond. Make sure you follow those.
Oh, yeah, so just what's on the trial docket, but somehow we got here today. If we could just put it back on the trial docket, this one needs a trial.
Why get loans on? Oh, man, this thing's old, too.
For the previous prosecutor had indicated they were going to dismiss, and then it got reassigned, and now they want trial, so.
There's an offer that's been relayed, Your Honor, but it's, I don't think it's going to be resolved without a trial.
Okay, when can, just getting over, when can we?
Special DWI trial docket in March. Okay,
it's gonna be done then. So what prosthesis do you have now because of bond conditions?
He's got an interlock.
I'm asking. What is from you, if you can remember?
Sorry?
What do you have?
I have
To start your car, what does it take?
I got to blow in and start it. In 10 minutes, I got to blow it in the meeting out. In 30 minutes, I got to blow it off.
He's been doing great.
That's got to be an annoyance on a trip to California or something.
Try to stay in Texas.
Okay.
Don't be at all.
All right. Well, yeah, you're here because of 2 prior convictions of DWI. So you're fixing, I guess, whatever mess there may be.
Yes, sir.
Doing better.
Yes, sir.
Because these are difficult situations to deal with here in this room when we have trials, especially in cases where somebody's been injured or killed in an accident.
Well, he wasn't trial judge, so that's why we need a trial. He was parked in a parking lot asleep. And they will try to prove operating.
Your Honor, there's
It's gonna be
extensive case
immaterial.
law that infers operation from that, but that's for trial.
Making the right decision, sleeping it off in a parking lot. They want to treat him as if he was going the wrong way down Interstate 10, and we'll have a truck.
Where were you sleeping? Where was
Oh, the Sea Ranch Cafe parking lot.
Okay. Is that where you had been? At the
But Judge,
I mean, I'm just asking if that's where you've been. That's where you were
Yes, sir.
at the time? Oh. You jumped at that one for old fast.
I mean, yeah.
Look at you go. Man, look at you go.
You know, lawyers could talk.
All right, get a reset.
Sir.
Wayland.
So just to be clear, he was sleeping it off in a parking lot, and they still want to charge him with a DUI? I have such a problem with that. Obviously, we don't know all the facts, but based on just that, serious problem. Let me know what you think in the chat. But it's, he's trying to do the right thing.
We could just come back on him doing it in 6 weeks. I'll continue to work on this.
Okay, how much time do you want?
6 weeks.
I'll give you 4.
Really?
Well, yeah, that's, you've been in this for a year. January 29th of last year. We're gonna move forward one way or the other.
Understood.
Okay. Need 4 weeks, 4 weeks, okay?
This go around here and get it.
On Mr. Levens, I don't see any criminal history.
Neither one of my voting law cases have any history.
Well, this is fixable.
You know, they do these voter safety checks, which are real constitutional.
Have you been on changing that law? Have you done?
I'm working on, but you know, again, the lobby is pretty. So.
Marion.
Oh, we have one more.
Van Meter.
Yes. She goes about that, George.
Oh boy, this one's really.
This one's
for 2 years.
Yeah, this one's a little.
No,
She got my bond conditions and down the grade, and she.
When are we gonna do something? One way or the other?
They made me an offer today. I'll convey it, Judge, if we can. 4 weeks. Yeah, with the rest of mine. So, just come back.
Why is that? I have Inland Falk here.
Sure.
Inland Falk.
Oh, yeah, Karen.
Oh, we don't do that. 25 CL 1228. Are you, you're Inland Falk? All right, Mr. Falk, now you were charged here in 25 CR 1228 with the second degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed up back in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 257. So if all of this is true, you are looking at habitual felon status, no less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? So that's what the guy was facing yesterday in yesterday's trial, who got 55 years in prison. You are under arrest at this moment. Do you understand? Yes, you are under arrest. There's a warrant for your arrest. And the police, the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got to answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked due to this warrant. And what was his bond before? What was your bond on this?
I think it was 20,000.
20,000 for habitual felon and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond on this new indictment. So he's just make bond.
So I don't find this bond enough at $25,000 anyway. Who said that? But you are a habitual felon, sir, and these are two prior violent crime convictions and then a serious illegal possession of a controlled substance. And now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle. So your bond is increased to $100,000. There's a way to avoid all of this, is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You cannot leave the home except to and from work, most direct route possible, to and from hospital care, to and from acquisition of food. And those are the other purposes. And that's the way it is. Do you have an attorney?
Also,
Are you unable to hire somebody? Fill out an indigent form and an attorney will be appointed to represent you. We'll appoint somebody today. Some public defenders. You're taken into custody. That's the rulings of the court. No, sir. Sir, your bond is too low. Sir, you are a danger to the community. Your bond is far too low under the circumstances that we have. Plus, there's a warrant for your arrest, and it's not a debate, sir. Follow the rules of the court. Thank you.
We'll just get her to fill out the report for the jail.
Next is Jaquan Lazard. Next is Bruce, Curtis Adams.
Yes, sir.
You got that shot.
And you were Curtis Adams.
Yes, sir.
Chris Ray.
Yes, sir.
23 CR 1728 is now called. Curtis Ray Adams, who's here with Mr. Smith, Bruce Smith, his attorney and the state's attorney. You were charged with the third-degree felony of operating a motor vehicle in a public place while intoxicated, and you have 2 prior DWI convictions, so it becomes a more serious crime, a third-degree felony. Does the defendant waive a formal reading of this indictment and arraignment to proceed?
Yes, sir.
In summary, paragraph 1 alleges that on or about December 23rd, 2022, in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. The second paragraph of this indictment alleges that you have 2 prior convictions in 2012, 2013 out of County Court at Law number 2 of Jefferson County, Texas for DWIs, or operating motor vehicles in public place while intoxicated. Paragraphs 1 and 2 constitute a third-degree felony, which carries with it a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what we've discussed so far?
Yes, sir.
An agreement has been reached with your attorney and the state that you would be pleading guilty to this offense. Whatever sentence shall not exceed a cap of 10 years in prison. And it says the defendant is going to request, defense is going to request probation. So we call this a cap, which has options. You could be sentenced to no less than 2 or more than 10 years confinement in prison. You could be sentenced from no less than 2 up to 10 years in prison, and that could be suspended and you could be placed on regular probation for up to 10 years. I think those are our options. Yes, sir. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
What we will do is enter pleas at this time, then have a pre-sentence report prepared. We'll come back later in a few weeks. Everybody gets to add additional information you want the court to consider, and then the court will make the decision. How do you plead to paragraph 1, charging you with this DWI, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges these 2 prior DWI convictions in 2012 and 2013 out of the County Court at Law 2 of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
Tell you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered in without objection. Among other things, this states you were mentally competent to enter your guilty plea. It's really involuntarily made. You know, it's within the charge goes on back and it's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is tendered and made a part of the record for all purposes. All right, you're going to order a pre-sentence report and return back
February 13th.
February 13th, 2026, 9 a.m. And then we will determine what the appropriate resolvement as a Senate should be in this case. Please get a reset.
Thank you.
Silent here.
It's TCF Live on a Friday. I hope you're all having a good day so far. I know I am. Always good to be with you guys. And why do we call it a Super Friday here at TCF Live? Because regular Fridays are for normal people, and we're all extraordinary. So, quick programming note, starting Monday. So, yeah, just a couple days from now. This show will start an hour earlier, 9 a.m. Eastern, 6 a.m. Pacific. It will become a 4-hour show. The 4th hour will be a little bit different, though, than the first 3, so be sure when you're here with us on Monday to stick around for the 4th hour. Let's change things up. Let's go to Florida. Wade Mercer's first appearances.
Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of 1 count of murder. It's a homicide charge. It's essentially an open count, which means at this point it hasn't been defined whether you're going to be charged with a first-degree murder or something else. Mr. Smith, I want to address your bond status this morning, but before I do so, I'm going to listen to the attorneys and see if they have any additional information. Mr. McDaniel, anything on behalf of Mr. Smith?
No, Your Honor.
Mr. Mitchell?
Hey, well, he did turn himself. I will say, Your Honor, I guess he did go and turn himself in when he found out about the warrant. So just take that. I don't think it's a major flight risk.
Okay. Mr. Mitchell?
Your Honor, the state is reviewing about possibly filing a motion for pretrial detention. We may make that decision probably on Monday, but for today's purposes, we can just do a regular bond analysis.
Mr. Smith, I'm going to set you no bond to the nature of the charge, due to the nature of the charge at this point. Mr. Smith, that may change. But for right now, at least for the time being, it's as serious charges we get. So you've got no bond for now. The public defender's office, if they think you're entitled to a bond, your attorney, either hired or appointed, will file an appropriate motion. But for right now, you've got no bond. Mr. Smith, do you have any questions?
No, sir.
All right, sir.
All right.
We do have friends and family here on the bit. Al Mateen. Mr. Almateen, good morning. Mr. Pittman is here on your behalf. He's just here supporting you. And speaking on your behalf. You're here because you've been accused of one count of failure to register a motor vehicle as a sexual predator within the requirements of Florida law. There is probable cause in the complaint. I'm going to listen to the attorneys, and then I'm going to set your bond, Mr. Mateen. Mr. McDaniel?
John, we just asked for a reasonable bond.
Mr. Mitchell?
Same, reasonable bond under the circumstances.
I'm going to set your standard bond. I normally would set for this charge at $5,000. Your bond's $5,000 cash or surety. The allegations are you've owned a vehicle since June, roughly, and haven't registered it. That is, that if that's proven, that would be a violation of Florida law. So that's the basis for the charge. So it's a $5,000 cash or surety bond. That means you can go through a bondsman. You don't have to put up all $5,000. That's what a surety bond would be. I'm also going to ask the jail to give you and Mr. Smith a court date. And I forgot that on Mr. Smith. That would be when, Madam Clerk? February 3rd. Please give both of them a court date for February 3rd at 8:30.
Yes, sir.
Court starts usually about 9 o'clock. We give the notices for 8:30, and that'll be in the other courtroom down the hall. They'll give you that notice before you try to post bond. They'll give you that notice. Do you have any questions, Mr. Mateen, Al Mateen?
No, sir.
Mr. Pittman, you have any questions, sir?
No, sir.
All right. Wish you the best, sir. Thank you for coming, Mr. Pittman. Next we have, is Mr. Tappan, is he there this morning, Mr. McDaniel?
No, Your Honor, he's not.
So the clerk made me aware this morning, or I was told this morning, that the complaint actually had 2 counts of battery, 2 different alleged victims. It was a little confusing because when you read the first sheet, it showed 1 victim, but there was another sheet under that. There was probable cause for 2 people, and I thought they just chose to charge 1. Apparently, there were 2 first sheets and 2 second sheets. Instead of doing 2 on 1 complaint and listing 2 charges, the officer chose to do 2 different, completely different complaint affidavits. So instead of 1 charge, there's 2. There's 2 alleged victims. So it's going to double the bond I set yesterday. So Corporal, please show whatever bond I set for him in 1 count. He actually has 2 of those, 2 different victims, and the condition, no contact with either of those people, and the bond will be twice the bond I thought it was yesterday based upon there being 2 cases. Any questions about that, Corporal? Thank you.
No, sir. Thank you.
Thank you. Next, we have Daryl Powell. I only have 2 more cases. Mr. Powell, good morning. Mr. Powell, you're here because you're accused of violating the terms of your probation, Mr. Powell. There's a no bond warrant in that case. I want to arraign you this morning, Mr. Powell, because I want to get you an attorney appointed if you want one. Mr. Powell, would you like to have an attorney appointed to represent you?
Like a paid one, like I don't got no money.
Just say yes, sir.
Yes, sir.
Okay, I'm going to appoint you a lawyer if you want one, and if you decide to hire one later, that's great. But for right now, I want to get you a lawyer. So we're going to appoint the public defender's office to represent you, Mr. Powell. Listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, we're going to interplead not guilty. Ask to set this on the February 5th court docket, and I advise you that a public defender will come by and speak to him prior to that hearing.
February 5th, Mr. Mitchell, anything?
No, Your Honor.
And Mr. Powell, February 5th will be your court date. Mr. Green or someone with the public defender's office will see you before then. Do you have any questions?
No, sir.
Have a good day, Mr. Powell.
All right.
I think the last case we have is Anna Augustine.
Yes, Your Honor.
Miss Augustine, good morning. Miss Augustine, you're here because you're accused of 6 counts of petty theft or retail theft, 1 count of scheme to defraud. Miss Augustine, I've read the complaint. There is probable cause for the charges, ma'am. Miss Augustine, I show 1 charge that was allegedly occurred when I was 7 years old. That'd be 1978, and that case was dismissed. Have you ever had any other charges besides that old case that was dismissed?
None ever, no.
Excellent. That's great. Let me see if the attorneys have any additional information. I'm going to address your bond or your release status. Mr. McDaniel.
Your Honor, she's lived in Jackson County, I think, for 20 plus years. She owns a house here. I mean, she's 73 years old. She's not going nowhere. We'd ask the court to consider some kind of, or some kind of release option to show back up for court. It is what it is, but she's not going nowhere, Your Honor. And I don't think.
I have no place to go.
Thank you, Mr. Mitchell. Any input from the state?
No, Your Honor. We'll leave it to the court.
Ms. Augustine, I'm going to set you the normal bond I was set for these charges, but I'm also going to offer you a conditional release because of your criminal history. So the bond is $2,500 per misdemeanor, $5,000 on the felony. That would be 15 plus 5 is 20. $20,000 cash or surety is the bond. If you want to accept the conditional release, I'm glad to offer you a conditional release based on your history, ma'am. You will have a condition, no contact with any Walmart while this case is pending. It doesn't matter if it's the Mariana Walmart or another one. No, you can't go to any Walmart, the alleged victim, while this case is pending. Ms. Augustine, I'm sure that Mr. McDaniel has already explained to you the difference between the conditional release and the bond, but do you have any questions about that, ma'am?
The conditional release is when I pay for the monthly charge?
You pay a monthly supervision, and you have to report in once a week by phone and stay out of trouble and follow some other rules.
Okay.
Is that what you want to do?
Yes.
So what's going to happen, ma'am, is they're going to bring you to the courthouse because that's where the conditional release office is at. You're going to meet with one of the conditional release officers. Mr. Goodson probably will go over the release with you. He'll answer any questions you have, and then you'll be free to go. Ma'am, the jail's going to give you a notice for your court date. Your court date will be February the 3rd at 8:30 a.m. will be your court date. That's the day you have to be in court to see Judge Garcia. Ms. Augustine, do you have any questions?
No, I don't think so.
All right, ma'am. Wish you the best.
Thank you, Judge.
Thank you. So, Mr. McDaniel, I know there's one thing I want to talk to you about off record about an issue that I'm sending an email on. Hopefully we can get straightened out. But anything else from the public defender's office on record, Mr. McDaniel?
No.
Short day for Judge Mercer. Let's head back for a few more minutes to Judge Stevens.
Texas versus Trent Sean Mixon. Is that you? Present with your attorney and the state's attorney. Does the defendant Mr. Gamma waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does.
Okay. In summary, sir, this indictment alleges two parts, two paragraphs. One paragraph, the first one, alleges that on or about July 1st, 2023 in Jefferson County, Texas, you operated a watercraft while intoxicated. You understand what you were charged with? Yes, sir. Paragraph 2 goes on to allege that you have 2 or more prior convictions of operating motor vehicles while intoxicated, beginning, 30 years ago. And in 94, out of County Court of Law 1, 97, County Court of Law 3, both of Jefferson County, Texas. Then 2013, here in the Criminal District Court, 2 convictions in September 2013, and then another one in 2017 out of the Criminal District Court here. So you've been a subject to third-degree felony because of prior convictions of DWIs 3 convictions ago. What was your sentence in this last case in December 7, 2017? 8 years ago. The last one you got. Pull that up. It's 17-27669.
I believe it was 6 years, Judge.
Dustin's generally right. We have a problem here that needs to be addressed differently than what we've addressed before.
Here's Judge.
Judge, this case is a little different, even though it is still an intoxicated offense. It's a voting while intoxicated. I know you have the probable cause affidavit, but it was a result of a safety check. And he was brought ashore and eventually arrested driving a jet ski.
Yeah, but it's personally for him and his own health. It was a .207. It was a breath test. I mean, that's 2.5 times the legal limit with these prior convictions. You've had an issue.
He has addressed his issue. The court has ordered a SCREM device. He's been blowing into it religiously. He's never failed that machine.
It's just been going
historically. Yes,
too long of criminality, but it can't be good for your health. and also the safety of others when you're operating vehicles or watercraft, right?
Yes, sir. He's asking you, it's not good for your health.
Well, I mean, what are you doing to address your alcohol issue? What are you doing? Because, I mean, you've been held accountable since 94 and you're still misusing, overusing alcohol, right? That's what happened here.
Yes, sir.
So I'm asking, what are you doing to fix this?
You still drinking?
We don't want you back up.
Yeah, I'm not drinking.
When did you stop?
Oh, I've been stopped for a minute.
Since July of 23? This is when this happened.
Yes, sir.
So that's that's 2.5 years. Okay. We hadn't had any problems since then.
Well, I think you had mentioned the breath test 0.2. I think it was pretty close to that, but I thought it was just a little lower, but I don't, 0.18. I splitting beans, but I think he wanted to make sure he didn't mishear it.
I believe the 0.2 came from their VBT.
Yeah, that's what
VBT.
Yeah. But the actual breath test was a 0.185.
Yeah, he quit drinking as a result of this, Judge, but he can't prove that other than when the court ordered on the SCREM device to monitor him, he has not failed that SCREM device at all.
Yeah, and then at the jail, he provided 2 breath samples of 0.185 and 0.180, but that 0.207 was still pretty close. Yeah, because it took a little while to get those subsequent samples drawn, but I mean, that's, and it's been 2.5 years, but we hadn't had any problems at all.
No.
Right? Yes, sir. Do you go to Alcoholic Anonymous or anything, any programs like that?
I was, and then I have a system. He works plant work, so I'm working up there at the PALMG site, so I'm out there.
What do you do?
I'm a former on the tank side.
Well, you got responsibilities there, leadership, role modeling. They're not drinking on the job, are they? All right. What would you do about that? Hold them accountable. What would you do as a foreman? All right. So in this second paragraph, it is alleged that you have 5 prior convictions of operating motor vehicles in public places while intoxicated. Paragraphs 1 and 2 constitute a 3rd-degree felony if convicted. Do you understand what you are charged with here in this indictment? You are facing, God bless you. If convicted, a term of not more than 10 years or less than 2 years in prison, in addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes,
I understand the question. The agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison.
Yes.
Just want that to sink. Boy, that sounds horrifying to me. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must also serve at least 10 days in the county jail as a condition of probation. And there will be terms and conditions of probation, which are normal and customary, which include not operating a motor vehicle without an interlock device. Do that. You always have to have that in here. Is there any reason why we need to order any kind of program? Judge, there'll be a DWI program that's normal and customary. Anything else we need other than that, do you think, for him?
Judge, I would just say based on his track record of
2.5 years.
So improving that he's not drinking through the device, he's probably past that point.
You want to sign the bottom of it.
He is kind of missed my house. Put your hand on it. You said big names.
Should just put on top of it.
Now you can just put your hand on it. You can go there.
You gotta sign the bottom line.
Oh, I'm sorry, the judge.
I'm asleep on the job. I know how you are, Dustin. You're reluctant to put your name on anything here.
He's good.
All right. Do you understand here what you're charged with in this case, in these two indictments, in these two paragraphs of this indictment, sir? How do you plead to paragraph 1, charging you with operating a watercraft while intoxicated, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? And those prior convictions here, there are 5 of them from 1994 through 2017 of DWIs operating motor vehicles while intoxicated. You understand fully what this alleges, and are these allegations true and correct in paragraph 2, and are you pleading true and correct to those voluntarily?
Yes, sir.
I've shown you what's marked as State's Exhibit 1. You've read this or discussed this with your attorney. Are the provisions in paragraph 1 all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Until you're satisfied with the representation provided by your lawyer, all truth shall help you God. State, is all that true? You've got to, you can't take a nod. You've got to express it out loud. That it is all true.
Yes, sir.
Okay. State's Exhibit 1 is part of the record without objections. I'm going to follow this agreement. Anything else to add?
Just that Judge, on the 10 days, because he does work at the refinery and he's a foreman, we'd ask that the court would allow him to do that on weekends starting next weekend.
Okay. Are you, you're free on weekends to?
Well,
have you made arrangements to do it?
Sure.
You're going to have to report on or before 6:00 p.m. each Friday. And then they release you on or before 6:00 Sunday. And you get 2 days credit. And so it's going to be 5 successive weekends.
Yes, sir.
Which I hear is painful to go in, you leave and you go, oh, I don't want to go back to there. And then you got to do that 5 times. But we're going to accommodate your request so that you can handle your job responsibilities. Most importantly, make sure you do that soberly.
Yes, sir. You can flip this one. Yeah, there was that sheet. No, that's fine.
All right, I'm going to make the findings that Mr. Mixon, you are pleading guilty to paragraphs 1 and 2 and true to paragraph 2, constituting a 3rd-degree felony of boating while intoxicated with 2 or more prior DWI operating motor vehicle in public places while intoxicated convictions. This is a 3rd-degree felony. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now so find you guilty beyond a reasonable doubt of this 3rd-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice prison for 10 years. But I'm going to suspend that confinement, place you on regular probation for 10 years. There will be terms and conditions of probation that the probation office is going to go over with you. When I have signed, make sure you understand them fully. You will be held accountable for those. If you fail to follow those, your probation can be revoked and you can be sentenced up to 10 years in prison, which you don't want. There, among other terms and conditions of probation, you must serve 10 days confinement in jail. We will do that, order that to be done on 5 successive weekends. You must report on or before 6:00 p.m. each Friday for 5 successive weekends. When can you begin that?
The 16th, which would be 1 week from today.
1 week from today, January 16th of this 2026. You understand what has happened today, sir? Okay, please see the probation officer. Good luck.
That's pretty fine. No, fine. No, fine. I need Mr. Mixon to come over here just real quickly. Oh, do you want to do it? Okay, real quickly.
All right, we'll see how that goes. But I've been on record before. Whenever it's a longer probation like that, a 10-year, they're not going to make it. They seldom make it. I would argue it'd be better to give him prison now. But, you know, maybe I'll be wrong. Hopefully I'll be wrong. Hopefully he gets it all figured out and life is good. So let's change it up. Let's go to the great state of Tennessee. This is Judge Wolf. He's just taken the bench. Let's see what's going on.
That's a matter a little bit out of order, so we'll take the first case is State versus Cody Hunter Ragsdale. We are ready on that motion to revoke bond. Bring your client around. All right, this is the state's motion. Mr. Brooks, are you ready? All right. Do you wish to put on proof or you want to make an opening statement? All right, call your first witness. If you will raise your right hand, be placed under oath. We'll pull that microphone toward you. There you go. Thank you.
Can you please state your name for the record? Douglas Carl Jr. Weaver. And Mr. Weaver, do you know a Cody Ragsdale?
Yes, sir, I do.
How do you know Mr. Ragsdale?
From an incident that occurred at the gas station and pursued to my house that evening. I don't recall the exact date.
All right. Would that have been on October 20th, 2024?
Yes, sir.
Okay. What exactly happened at the gas station?
I went into the gas station around 6 o'clock. Not 6 o'clock. I got off work around 4 o'clock and I got to the gas station around somewhere around there. I don't remember the exact time. I got a 12-pack of beer. I went out to the car and my buddy's sitting out there screaming and yelling at some dude with a bat in his hand because the guy just spit on my window and got back in his car.
The question is, your objection is on what basis? Hearsay?
There's a DNA swab.
When there's an objection, sir, just be quiet until I can make a ruling on it.
I have no objection. I mean,
all right, we'll sustain the objection.
Can you testify to what you saw?
When I came out to the parking lot, I saw my friend yelling at him, and he was in the driver's seat of the car laughing and pointing at the car and saying he wasn't going to clean it up. He wasn't going to clean it up.
Okay. And did you ever see what what Cody was referring to?
It was a gigantic loogie that had blood in it on my window of my car.
All right, and that's something you actually laid eyes on?
Yes, sir.
Okay, and he was saying, I'm not going to clean it up.
Yes,
I'm
sir.
not going to clean it up. Okay. Do you see that person here in the courtroom today?
Yes, sir.
Where is he sitting and what is he wearing?
Right there, wearing a red Hollister sweater.
Okay. And after that, what did you do?
I proceeded to grab the bat from my friend and tell him to please clean it off the window. And I had no problem. I didn't know who he was. And I just had no clue why he spit on my window. And he refused and then told me that he knows who I am and that I robbed him and pretty much that he wasn't going to clean nothing up. And then he grabbed some thing out of the door of his car and went to go get out of the car with it and was pretty much telling me he wasn't going to do nothing and that started calling me B-word and cussing at me, telling me that I robbed him a couple years ago and that he's not cleaning nothing up and that he knows me, he knows where I live and all that kind of stuff.
Okay. Did he make any other type of threats at the gas station?
No, sir. He just told me he knows where I live and that he's got something for me, is what he said.
Okay. And what did you do after this? How did this end at the gas station?
He went to step out of the vehicle with what I assumed to be a screwdriver or something like that. And I swung my bat at his vehicle, and then I got in my car and went to go leave. And he followed me almost all the way to my house and then turned around. And I don't know where he went from there. But I got home. I told my dad what happened. I was sitting there. I opened up a beer, started drinking it. My buddy that went to work with me had left. And 20 minutes go by, a car pulls into my driveway, and my brother and his girlfriend are outside painting pumpkins. And they tell me there's a car coming down the driveway and there's people getting out of it. And then 5 seconds later, you just start hearing gunshots going off.
Okay. And where were you when the gunshots started?
I was sitting on my couch at first, and then as soon as they told me somebody was in the driveway, I ran out to the porch to see what was happening because I already figured pretty much what was happening.
Had you made it outside before you heard the first gunshot?
No, sir.
Okay. So while you're still in the house, you hear what you think at the time is a gunshot?
Yes, sir.
Okay. And what time of day is it when this is occurring?
It was right before it got dark. I don't remember the exact time. It was around 4 something. It might have been a little later than that. I don't recall exactly.
Because this happened in the fall. You said October.
Yes, sir. Right when it was about to get dark. It was like 30 minutes before it got dark or something like that.
Okay, so there's still a light out.
Yes, sir.
And what does the makeup of your yard look like? Is it treeless?
There is some trees, but I can see in the fall, because there's no leaves, all the way down to my drive. I can see all the mailboxes next to me and everything down the hill.
But when you exit your house, what are you able to make out?
I see the truck that I seen at the gas station at the bottom of my hill, and there was 2 guys standing there shooting. And after that, my dad went and started running down there with his firearm, and I just tried to get my son and my wife and everybody to the back of the house to get them away from it because I didn't know what was really going to happen. If they were going to run up my hill or something like that. I was scared.
Right. Were you able to make out any individuals?
I couldn't make out individual faces. I just remember seeing the truck that was at the gas station. It was a very easy to remember. That was the same truck because it was a crappy paint job and had a busted mirror on it.
Right. And you said you weren't able to make out the people. Did you see where they were at?
They were
like where the shots were coming from?
Yeah, they were about 20 feet behind my gate, like into the driveway where they pulled all the way in, and I could see them standing at the back of the truck.
I think you just said what he's able to see, Judge. That's the question.
I think the question is, what was he able to see? And he's explaining what he could see. He said he couldn't see the faces of the people, but he's now describing what he saw. Overruled.
So I seen them standing at the back of the truck, and that's when I told my wife, run to the backyard, because we live in a mobile home, and they're not really going to stop bullets. So I was just wondering, how are we going to get them away from all this? Because I thought they were going to try to force their way up the driveway or something. And that's the only thing I was trying to do at that time, was save my family from getting hurt.
Okay. So, yeah, I mean, were you able to make out with your own eyes how many people, like any other descriptors aside from, you can't make them out particularly, but were you able to make out any descriptors of the people?
I seen a tall gentleman, and he was wearing a black hoodie or something around there. I have no clue who it was, and he was holding a long rifle. It looked like, I couldn't tell anything else with that. And then I seen him, I was assuming somebody on the other side of the car, I don't know who it was, and they were holding what appeared to be a pistol, because like I said, you could see directly into the bottom of my driveway. There wasn't any trees or anything blocking the view. And after that, my dad was running down the driveway, and they started to get in their car and try to leave.
Were you able to make out male or female?
I couldn't tell if it was a male or female, but I've never met a woman that big.
Okay. All right. So one tall individual with a long gun, one other individual with what appeared to be a handgun from your vantage point. About how many shots at that time? Like, how long did this last?
It seemed like it lasted for a long time, but I know it didn't. And it felt like they were just shooting and shooting. But to me, I thought it was around 30 shells. I don't know what was ended up being collected or anything like that, but that's what it sounded like to me, because you could tell they emptied everything they had in their gun before they left.
Okay. All right. And where were you when it's like when the shot stopped?
I was running back to the front of the house trying to see where my dad was, because last time I seen him, he was running down the driveway, and that's when they were already peeling out of the driveway.
So had you had an opportunity at that point to get your family to safety?
Yes, sir.
Okay. And where were they at?
I put them in the backyard. We have a shed back there, and I stuck them behind it.
Okay. And who was all on scene at the shooting?
My wife, my brother, his girlfriend, my son, my mom, and my dad.
And who was all in the house at the time when this started?
My mom, my wife, my baby, and me.
And where were the people outside when you exited the house? Where did you see your family and friends outside?
My brother and my sister-in-law were sitting on a picnic table that's right in front of our front porch, right in front of the driveway, and they took off running to see that a gunshot, and really in the car pulling up, and it was 5-6 feet away from where they were sitting, where one of the bullets were recovered.
Okay. And then, was there any damage to any property?
There is a gunshot hole in the side of my trailer that penetrated through my dad's bathroom and then went through my dog's cage while he was sleeping in it and hit the gun safe that he has in there.
Okay. I guess was that bullet recovered?
Yes, sir.
Was anybody injured?
No, sir.
Okay. Did you have another incident occur with Mr. Ragsdale?
Yes, sir.
All right. Would that have been in February of this year?
Yes, sir.
All right. What happened? Where did this incident happen?
It happened at Thunder Alley, the bowling alley.
Okay. And going back, your house, where is that located?
It is approximately 20 minutes from the bowling alley.
Okay. And that's where
Mr.
this.
Brooks, did I understand you to say it was February of this year?
Yes, sir.
Well, since February hasn't arrived in 2026.
I'm sorry.
just wanted to
February
clarify for the
2025. Yeah. Thank you, Judge.
We
My calendar hasn't switched yet.
we were time jumping or something.
Yes,
so-
sir. No, my internal calendar has not reset yet, apparently.
Got you, okay.
So February 2025. Okay. The shooting, what was the address of this shooting?
1454 South Bear Creek Road.
All right. Is that located here in Dixon County?
Yes, sir. It's on the Dixon County Bon-Aqua line.
Okay. Now, where did this next incident happen in February last year?
It happened in the Thunder Alley, the bowling alley in Dixon.
Okay, that's located here in Dixon County?
Yes, sir.
Okay. What happened at Thunder Alley?
I was bowling with my friends all night long, and then some lady came to my table and started asking questions about me and asking if I was DJ and all these weird questions. And I pretty much talked to her for a minute and then told her I didn't want to talk to her anymore. And an hour maybe goes by, and I get up and went to go do my last bowl because we're about to leave. And I saw Mr. Ragsdale walking towards the snack bar because he was heading towards the door. And when he looked at me, he put his finger up and then said something to me. So I said, I have a restraining order against you. You're not supposed to be here. You need to leave. And then he starts cussing me out and just saying all sorts of weird stuff, and tells me again with the lady I'm with that that he knows where we live and that he's not done pretty much with us. And when he was going to the door, he stopped and turned around and pulled his shirt up, showing he had a gun in his hip, and then started air humping, like thrusting in the air.
Right. And when he displayed his firearm, how did that make you feel?
It made me scared that he was going to wait for me to leave the bowling alley and then try to shoot me.
The person that displayed his firearm to you that made the humping motions in the air, do you see that person here in the courtroom today?
Yes, sir.
Where is he sitting? What is he wearing?
He's sitting right there, and he's wearing the red Hollister sweater.
Okay. Was somebody with you that day?
I was with 3 friends.
Okay. And who was anybody standing near you when he displayed his firearm to you?
Yes, sir.
And what I mean, you kind of gave a paraphrase of what he was saying. Do you know any specifics of what he was saying that day?
I think he was drunk, so he wasn't making very much sense to me, and I really didn't understand what he was saying, but I don't know for sure. And he was pretty much threatening the woman that was with me more than me that time, because she was getting in his face and telling him, you need to leave, you need to leave. And he was making more threats towards her saying that he's not the one, that he'll get something for the same thing he said to me at the gas station.
Okay. So, you said you seemed drunk. What do you mean by that?
He was pretty much stumbling around and slurring his speech when he was talking to me. And then based off of the humping the air in the middle of a wheelchair ramp, I'm assuming that might be a part of that, unless it's just mental error.
Did that end your interaction with Mr. Ragsdale that day?
Yes, sir.
Okay. And what time of day was that?
It was 8 or 9, somewhere around 8 or 9 at night, because we were about to go to Applebee's.
All right. And that incident several months after the alleged shooting?
Yes, sir.
Okay. That's all I have this witness, Judge.
Leon, you have questions?
Said that your name is Douglas Weaver Jr., is
Yes,
that
sir.
correct? But Douglas Weaver Sr. also lives in
Yes, sir.
and that is your home, correct?
Yes, sir.
Okay. And so you testified that you did not know Mr. Ragsdale and never seen him before.
Not to my knowledge.
And how was it that you were able to provide the name of Mr. Ragsdale to the detective in this case?
The picture we had at the gas station, we showed it to a lot of people, and we showed it to the friend that was with me at the gas station's wife, and she had rode the bus with Mr. Ragsdale for a couple years.
Okay, so you talked to, who is that person? Who did you talk to and gave you the name of Mr. Ragsdale?
Gannett, so I don't know her last name, but it was the picture that I had from the gas station I showed, and she said that is definitely him.
Okay, when did you get that picture from the gas station?
I do not remember the exact day that we went and got the picture. I think it was the day after the shooting.
Were you with the detectives in that?
No.
Were you with the detectives when they reviewed the footage?
No, sir.
You have talked to the detectives and law enforcement on many occasions in this case?
Yes, sir.
Okay, and approximately how many times do you think you've talked to a law enforcement officer regarding this?
3, 4.
Okay, and do you recall when you actually told them that you knew the identity?
Yes, sir.
Okay, and how was it that you knew that where Mr. Ragsdale lived?
Because he rode the bus with my neighbor.
What's your neighbor's name?
Gannett, I don't know her last name. She's Spanish.
How long have you lived there?
I've lived at my house for 11 years.
Okay, and how long does Lynette live there?
Probably 10.
Okay. And you don't know her name?
I don't know her last name. I'm not Spanish, sir.
All right. You know it, and you're just not.
Alzer Perez, you want me to spell it out for you? I don't know how to do that either.
And so you just started conducting this independent investigation based on what was your description of the person?
Yes, sir. Based off the fact that I had a picture of his tattoo on his forearm, and then he has the tattoo on his forearm.
Okay.
Kind of made the dots connect.
Okay. And you're saying that she happened to know Mr. Ragsdale, recognized the tattoo, and told you where he lived?
No, she did not recognize the tattoo. She recognized his face.
Okay. I just want to be clear. You said that at no point did you see Mr. Ragsdale or was able to identify Mr. Ragsdale at your residence the night that it.
Not to my knowledge.
Okay. Because you were in the house when the shooting started, is that correct?
Yes, sir. I was sitting on the couch right next to the front door.
And when the shooting started, you were, I guess you have a son. Did you tell me you're a son?
Yes, sir.
Okay. And you took the son and everybody that was in the house.
Yes, sir.
And you got them out of the house back behind a shed. And by that point, had the shooting stopped?
It was still going while they were running, but when I got back around to the front of the house, it had stopped.
All right. So you were running to the front of the house, and that is when that's when you said you were able to identify Mr. Ragsdale truck, or the truck that you had seen earlier at the gas station.
Yes, sir.
You were able to see that truck leaving the premises.
Yes, sir.
Okay. And did you say how far they had backed into the driveway?
It was after my gate, which is about maybe 25, 30 feet, they backed in another 20 feet. So it's approximately 50, 60 feet into my driveway.
Okay. So it's about a third of the way up the driveway?
No.
No?
No, my driveway is very long.
Oh, is it?
It wraps around a big hill right there, but you can see all the way down the side of it. It's just a little plot of land right there.
I guess as the bird flies, how far from where the truck, the maximum it entered into your property, how far was that from, say, the front of your trailer?
No, 75 feet, maybe 70 feet.
Okay. And I haven't been out there, but I'm visualizing, are there a lot of, is it open front yard, or are there trees in the front yard?
There is trees.
Lots of trees?
Nah.
No? Is it enough trees that where you don't have to cut the yard?
We don't usually cut the trees or the yard.
Okay, because the grass just doesn't grow under the amount of shade that it gets?
No, because
No.
it's in the woods.
It's in the woods. Okay, so you would then agree there's a lot of trees there, right?
I guess.
Okay. How many would you estimate, how many trees you have in your front yard?
10.
10, okay. Now, let me take you back to the gas station. At no point did Mr. Ragsdale get out of his truck?
No, sir.
Once you were outside? You don't know if he got out before?
No, I know he got out before.
Well, you were in the store, right?
Yes, sir.
You didn't see him get to the store?
No, I seen the passenger of the vehicle come out of the store.
Okay, all right. But Mr. Ragsdale, you never saw him outside the truck?
No, sir.
And you asked him to go clean up spit on the driver's side
Yes, sir.
window of your vehicle?
Yes, sir.
Okay. And he said that he wasn't going to do it?
Yes, sir.
Okay. You actually went and got some paper towels from somewhere?
Yes, sir.
All right. So is it fair to say that kind of ticked you off a little bit?
Yes, sir. And if he would have just been a man and wiped the damn window off, then it would have stopped a lot of aggression. But the threatening was what really started the aggression.
It would have stopped a lot of aggression on your part, right?
No, his part.
Okay. Well, you said that you had grabbed the bat before you asked him to wipe the spit off.
No, I did not grab the bat before. I did not
Okay.
say that.
Well, then when he refused, then you
Yes,
got
sir, I
more
took the bat from my
aggressive
friend.
and took the bat from Cameron.
Yes.
Now, Cameron was in the store with you as well.
No, he was not.
No, he didn't go into the store at all
No,
with
he
you.
was in the parking lot.
Okay. The entire time?
He might have went in, like I said, I do not recall exactly.
Okay. So you don't know if Cameron saw him spit on your car or not?
Yes, I do know.
Because of what Cameron told you?
Yes.
But personally, you don't have any personal knowledge that Cameron knows that he spit on your car?
No, but I trust my friend.
And you trust your friend to the point where your friend already has a bat
Yes, sir.
out. And what's he doing with the bat?
Trying to get him to clean my window off because what kind of sane human being spits a bloody loogie on someone's window?
And you thought that was appropriate?
I don't know what's appropriate because that's not my say-so.
Would you consider a bat a deadly weapon?
Yes.
Okay. And how do you get someone to clean spit off your window?
I asked him to clean it off, and then he pulled his little shiv out, and that's when I started to use the bat as telling him, hey, you're not going to get out of that car and try to stab me, sir.
Well, no, the question was, you were trying to force him. Cameron was trying to force him, and then you were trying to force him to clean spit off your window, correct?
Yes, after he assaulted my vehicle and vandalized it. Yes, I did.
Okay. He assaulted your vehicle?
And vandalized it. Yes, he did. He spit on my vehicle, and that is disgusting, and I don't know what diseases he may carry.
Were you going to use the bat?
No.
Okay. But you did use the bat.
After he tried to get out of the car.
And vandalized his vehicle.
After he spit on my car, yes.
No, it was after you took.
Yes, I
took the
said
bat
yes,
into
after
your
he
hand.
tried to get out of my car.
Hold on just a second. Wait until he finishes asking his question before you begin answering it, and you will let him finish his answer before you ask the next question.
Yes, sir.
And this is somebody you don't know at all, never met him before in your life?
Not to my knowledge,
All
for
right.
the 5th time.
You have a bunch of run-ins with complete strangers like that?
No, sir.
No? You don't have any kind of record of assault or anything like that?
No, sir.
All right. And Well, I guess back to the question, you were gonna threaten or intimidate him
Yes.
with this bat so that he would get out and clean spit off the window?
Yes.
Okay. And in doing so, you struck his vehicle
Yes.
and knocked the mirror off the driver's side door,
Yes.
the same door that he's sitting beside
Yes.
in the driver's seat. Is that correct?
Yes.
Okay. And you said that you hit the mirror because he actually pulled a knife out of his pocket.
No, I did not.
No, okay. What did you say?
I said that he pulled something that appeared to be a screwdriver out of his pocket.
Screwdriver.
That's what it appeared to be.
Now that's pretty important. Did you tell the?
That is what is wrote down in the report.
Did you tell the police a screwdriver?
Yes, that is what is wrote down in the report.
Okay. Have you written your own report?
When I wrote my statement, I said what looked like a screwdriver, and he was using it as a knife, trying to use it as a knife, holding it in his hand like this.
Okay. And sitting in his.
Yes, he made sure to wait until I got out to the parking lot before he left because he wanted to see me looking at the spit on my window.
Okay. So wrapping that up, he still never got out of the truck, did he?
No, sir.
This entire incident, and you get in your vehicle and leave.
Yes, sir.
And Cameron gets in on the passenger side.
No, he was in his own vehicle.
Oh, he was driving?
Yes, sir.
Your vehicle?
No, he was driving his own vehicle, as I just said.
Okay, so he didn't ride to the store with you?
No, sir. He followed me.
Okay. And you've been drinking?
No, sir. I just got off a 12-hour shift.
You say you started drinking once you got home?
Yes, sir.
Okay. And the night of the bowling alley, were you drinking that night?
Maybe 2 beers by 4 hours.
And you were with your son?
No.
No? You said the female that you were with?
Yes.
Okay, was that a girlfriend?
No, sir.
Okay. Just a friend?
Yes, sir.
And who else were you with?
2 of my other friends that I go bowling with every Thursday.
Okay, what are their names?
Logan Work and Wade Lepowski.
And what is your friend that's a girl, what was her name?
Jennifer Fisher.
And you said that Mr. Ragsdale was with a girl.
He was with a few people. I don't recall who any of them were.
And you know how many people he was with?
Maybe 4, 3, I don't know.
Okay. And one of those was a girl, correct?
Yes, sir.
Or at least one was a girl.
Yes, sir.
And that girl came over and was wanted to talk to you.
Yes, sir. She started initiating a contact with the other female and then started talking to me, asking me what my name was.
Okay. And she didn't, well, I'll withdraw that question. You didn't know if Mr. Ragsdale had sent her over there to talk to you?
No, sir. At that point, I didn't even know Mr. Ragsdale was in the bowling alley until I had went up to go bowl and he was leaving.
Okay. And you said y'all were almost getting ready to leave. You're
Yes, sir.
finishing up.
Yes, sir.
And I wanted to make sure I heard you correctly. Where did the only time that you said you saw a gun at the bowling alley
Yes, sir.
in Mr. Ragsdale's possession was when he was leaving and he lifted up his shirt?
Yes, sir. And then he started thrusting the air repeatedly for about 20 seconds.
Sometimes you talk a little fast for me. He was leaving and what?
He started thrusting the air for about 20 seconds with his shirt pulled up, and he just stood in the same spot in the wheelchair ramp.
He was doing what with the air? I'm sorry.
He was dry humping the air. Like he was pretty much telling me he was saying F me.
Like this?
No, like he was getting down on it.
Oh, okay.
Yeah.
Okay. Must be a new term.
Yeah.
So would you call that like some kind of sexual innuendo?
I don't know what it is. It was very disturbing and it made me scared because I was about to leave the bowling alley and I didn't want him to sit out there and wait on me to leave and try to do something outside in the parking lot. So I immediately called the police.
Okay. And you're saying with him doing that and making some kind of thrusting movements with his hip, you were able to see a gun?
Yes, sir. He made it very clear to show the gun.
Okay. And were you able to describe the gun?
It looked like a black handgun from what I could see. It was just the back of it hanging out, a little bit of it.
Okay. Did you have a gun?
No, sir.
At your house?
I did not.
Okay. And when he was making these thrusting, that's the only time he indicated, or that's the only time you could see him with the gun.
Yes, sir.
He didn't pull it out, he didn't touch it.
He had his hand on it when he was thrusting. He pulled his shirt up and held it up with his arms like this, and then had his hands on his hips.
Okay. Is that because his pants are baggy? Or?
Probably because he doesn't know how to wear a belt.
Okay. Just a couple more questions. You said you had a restraining order against him?
Yes, sir.
Okay. When did you take out a restraining order?
It was maybe a week after the shooting had occurred. Actually, I'm pretty sure the detective helped me make sure the restraining order was filed, and we had somebody that was supposed to be watching over my house for a day or two to make sure he didn't come back.
Right. This is the very first time you've ever testified in any of this?
Yes, sir.
Right?
Yes, sir.
You didn't testify to any kind of restraining order hearing or anything like that?
No, sir.
And you went back and looked at the video at the market. Did you go back and look at the video at the bowling alley?
No, sir, I did not.
Okay. That's because you said you already knew who the perpetrator was.
Yes, sir. And I called the police, and I figured they would handle everything from there.
Okay. And the girl that was with you,
Yes,
not
sir.
your girl, not a girlfriend,
No,
but
sir.
the girl that was with you that bowled with you that night, correct?
Yes, sir.
And had she been drinking?
She had one beer. She was driving that night, so she wasn't really drinking.
Okay, but you were drinking.
Yes, sir.
So I mean, were you intoxicated?
No, sir.
No. All right. She was so intimidated that she followed Mr. Ragsdale out of the bowling alley, didn't she?
No, she was telling him to leave because he was taunting me, and she knew that she didn't want me having any interaction with him at all because of the already pending case.
Oh, or are people able to tell you, hey, calm down?
Yeah, I was more or less scared than I was upset. I wasn't very angry or anything. I was actually scared for my life because I didn't want to leave and then him try to do something to me in the parking lot. That was the only fear I had.
It seems like you, instead of backing down or letting it slide or reporting it to the police, it seems like you react physically. Is that fair to say?
I did not at the bowling alley.
You did not do that at the bowling alley?
No, sir.
Okay. You got kind of upset the last time we were in court and came out and said some pretty
When
aggressive
Cody looked
stuff.
at me dead in my eyes, yes, I did get a little upset. And I think it is a little disrespectful to have the victim walking out to the parking lot with a man who just shot up his house. Would you guys do that with a rape victim?
We were already outside, correct?
Yes.
And you saw us outside.
And then Cody turned around and made eye contact with me.
And we were well down the sidewalk when you made
No,
sure
you
that
guys
you
were,
walked
like,
within
right in
feet
front
of
of
us.
the
One
door.
at a time, please. Wait for him to finish his question before you begin answering.
We were 40, 50 feet from the front door, and you walked within feet of us and said something to him first. Did
You
not?
guys were in the sidewalk on the way to my vehicle. Standing in the sidewalk on the way to my vehicle.
All right. You knew that we were trying to avoid you, right?
No, it made it seem like you were just standing on the sidewalk in the middle in the front of the building.
No, we tried to avoid you up here inside the courthouse and inside the courtroom.
I did not see Cody that day because when I came in here, I was told I had to leave the courtroom because there was no room.
No further questions.
Mr. Brooks, you have a redirect. Thank you, sir. Mr. Weaver, you may sit down, have a seat in the courtroom. You may call your next witness.
So, friends, while we wait for the next witness to come up, I just want to make it clear we're going to ride this for however long it takes. So far, my list of things: bloody loogies, sizable women, firearms, bowling alleys, mobile homes, air humping, unpronounceable Spanish names, and the Kool and the Gang reference to Get Down on It. This case does indeed have everything. So let's all continue to enjoy.
Step up, please. Come around, raise your right hand, be placed under oath. Have a seat.
You please state your name for the record?
Officer Joel Moss, City of Aaron Police Department.
Okay. Where were you employed on or about February 13th, 2025?
As a police officer with the City of Dixon Police Department.
Okay. Did you have an occasion on that date to respond to Thunder Alley?
Yes, sir.
Is that located here in Dixon County?
Yes, sir.
What brought you to Thunder Alley?
We were dispatched to a possible aggravated assault.
Okay. And what was your participation in that investigation?
As the initial officer and the investigating officer for that assault.
Okay. And where did you initially go as part of your investigation?
I responded to Thunder Alley. I made contact with the victims. I'd have to glance up my affidavit to get their exact names, but I made contact with the victims and also witnesses, got their statements, got the suspect information to include his vehicle information, put out the information over the radio for be on the lookout for on his vehicle, so that way the other officers could start looking for his vehicle. Then I left Thunder Alley and we started searching for the suspect's vehicle.
And were you able to eventually make contact with the suspect?
Yes, we were. And officers initiated a felony traffic stop at close to Highway 46 and the interstate. And we placed Mr. Ragsdale in custody.
You say Mr. Ragsdale. Do you see, are you referring to Cody Ragsdale?
Yes, sir.
Do you see that person here in the courtroom?
Yes, sir.
You describe where he's sitting and what he's wearing?
He's wearing a red shirt, sitting next to the defense attorney.
And when you first make contact with Mr. Ragsdale, does he make any statements?
He had made a spontaneous utterance to Officer Hagewood, advising that this was in relation to Thunder Alley. We had also located a semi-automatic handgun on his person.
So before questions ever asked, he said, "Is this about Thunder Alley?"
Yes, sir.
Okay. You said a handgun was found. Where was that located?
In his jacket pocket.
Okay. And can you describe that handgun?
It was a semi-automatic pistol. I would have to glance at my affidavit to get the exact model number due to the length of time since then, but I remember it was a semi-automatic pistol.
Okay. And did he give you any issues as he's been taken into custody?
Yes, sir. He refused to get in the back of the patrol car when I tried to place him in it, and we eventually had to utilize my OC spray him with it, then get him in the back of the car, and he continued to cuss us out. Had to push him into the back of the car forcibly to get him into the back of my patrol car because he did not want to get into it.
So how did he resist?
He kicked at the door and was pushing on the seat, refusing to get into the car.
Okay. Did he make any other statements in regards to the incident at Thunder Alley?
I do not recall.
Okay. Did you make any other observations about Mr. Ragsdale at the traffic stop?
As I recall, he was under the influence of, I'd have to double check my affidavit, but.
Would you like to refresh your memory?
Yes, sir.
Judge may I pass up his warrant?
You may.
Take your time, officer. Be able to refresh your recollection.
Yes, sir.
When you say you think he was intoxicated, like, I guess what led you to believe that was potentially?
He smelled of the odor of marijuana.
Okay. And I'll ask the question, like, did y'all do any field sobriety task or anything of that nature?
No, sir.
Okay. Is there any reason why y'all didn't y'all didn't pursue a DUI investigation?
I didn't see him driving, so.
Okay, so that would have been another officer to pursue that if that was the case?
Yes, sir.
Okay. That's all I have this witness, Judge.
McNally, you have questions?
Well, I take that, you weren't the officer that stopped the vehicle, correct?
No, sir, I responded as the backup officer.
Okay, but, and I guess that response to the stop of that vehicle, you know about how much longer that was after I guess your arrival at Thunder Alley?
I do not recall.
Okay, but were you the first officer on Thunder Alley?
Yes, sir.
Okay, so your involvement in this case deals directly with Thunder Alley and then the stop where some marijuana was found?
Yes, sir, and the firearm.
Okay. And did you interview Mr. Weaver Jr. at Thunder Alley? The younger gentleman that is one of the victims at the earlier shooting at his trailer.
I do not recall if he was one of the victims or not at Thunder Alley.
Please. All right. You don't know if you interviewed Mr. Weaver?
He was the younger gentleman that I saw come in who was interviewed or on the stand before me. Is that correct?
Let me go off on a different direction. Maybe we'll get there. You did interview people?
Yes.
At Thunder Alley? Okay. And from those people, you were able to get a description of the car?
Yes.
Correct?
Yes.
And you put that description of the car out?
Yes.
And at some point in time, you were told that, based on that description, did you, and based on your be on the lookout, did you say that this individual could have a weapon?
Yes, I did, because based on the interviews from the people at Thunder Alley, he had lifted up his shirt after an argument and showed the firearm, which was under his shirt. And the argument was based on allegedly Mr. Ragsdale had shot up a house of some of the people prior to the incident at Thunder Alley.
All right. And tell us what you remember. You recall who it was that told you about him lifting up his shirt?
I have the name written down in my affidavit, as I recall.
Okay. I didn't read the whole thing. I didn't want to delay the court, but I'm going to let you find it. Refresh your memory.
All right, so Mr. Weaver advised that Mr. Ragsdale approached him and lifted his shirt, displaying a gun he had on his hip, and put his hand on it.
And so now that refreshed your memory, is that right?
Yes, sir.
And do you remember Mr. Weaver Jr. saying that Mr. Ragsdale approached him?
Yes.
Do you remember Mr. Weaver Jr. saying anything about him observing the firearm while he was doing some kind of thrusting motions with his hip?
He said he had lifted up his shirt and placed his hand on the firearm, which was located on his hip.
Do you remember any kind of thrusting motion or any kind of
I do not
vulgarity
recall
or
that
anything like
exact
that?
statement, sir.
Okay. Would that have been important for you to include it in a report?
It might be on my main report, but for the affidavit, which states probable cause, no, that was not important.
You did do a report?
Yes, sir. I did a full report.
Okay.
To include victim statements.
Okay. And you, did you ever talk to Mr. Weaver Jr. after this incident?
No, sir.
Okay. So that's the only night that you've ever interviewed him?
Yes, sir.
And it was strictly about Thunder Alley?
Yes, sir.
And what he alleged to you as an assault by the display of a deadly weapon?
Yes, sir. And then follow-up investigations have been conducted by the detectives division.
What was his intoxication level, do you think?
I do not recall.
Did you smell any alcohol in him?
I know it was in a bowling alley with a bar, so I don't recall whether he was intoxicated or not.
And were you aware that, and during their statement, or anybody that you interviewed that night, were you ever told that someone followed him out of the bowling alley?
I do not recall, no.
And last question, did you secure the video at the bowling alley?
We were unable to retrieve it.
What happened?
I contacted Thunder Alley a few times. I was not able to get the video from them.
They had cameras, correct?
Yes, sir.
All right, and they had those cameras functioning that night?
The people working that night weren't able to get the video that night.
Okay, but you asked them for it that night?
Yes, sir.
Okay, and then you followed up about how much longer after that you followed up?
And the following few nights, Officer Purtle, who was also a security officer there, tried contacting the owner, trying to get a hold of them to get the video as well.
And you took the lead in this Thunder Alley investigation, right?
Yes.
Okay. And they told you, what was the reason that they didn't have the video anymore?
I do not recall.
Okay, but you would have put that in your report, that you attempted to get the video and they were unable to provide it for whatever reason?
Yes, sir.
Okay, thank you.
Brooks, any further follow? Thank you. All three may stand down. Mr. Brooks, you may call your next witness. Step right around here. Raise your right hand and be placed on the oath.
Can you please state your name for the record?
Detective Jim Gardner,
And where are you employed?
Dixon County Sheriff's Office.
And what is your position?
I am a detective.
And were you employed in that capacity on or about October 20th of 2024?
Yes, I was.
Did you have an occasion to respond out to an address on a shooting?
Yes, sir.
Do you remember what the address was?
It was on South Bear Creek. I don't recall, 1159, something like that. I'm sorry.
Pull that
I'm sorry.
microphone base toward you. If you can pull it close to you as possible.
It was on South Bear Creek. I don't remember the mailbox number.
Okay. If you would have wrote in your warrant 1454 South Bear Creek Road, would that
Yes,
be
sir.
correct?
Yes, sir.
Is that located here in Dixon County?
Yes, sir. It's in Dixon County.
And that was in response to a shooting?
Yes, sir.
Okay. When you get to the scene, what is your role?
I was on call that night, and I was dispatched out there because patrol was out there because the Weavers had called in and reported the incident.
Okay.
I was out there to investigate.
And was there evidence, once you get on scene, was there evidence of a shooting?
There was, it was 20 spent shell casings I recovered from the driveway. Yes, sir.
Okay. In the driveway area, you said?
Yes, sir.
Okay. You've heard Doug Jr. testify this morning. Would his testimony be consistent with where these shell casings were
Yes,
found?
sir. They had a gate that was approximately 25 feet from the main road. Maybe another 20, 30 feet from that is where there was evidence of vehicle tire tracks in the gravel, and on each side of the vehicle is where the shell casings were picked up.
And were they all, I mean, were they located in one area?
Yeah, it appears that wherever they were fired from, the rifle and gun were in the same location because they were all discharged in the same spots from where they would have been standing.
Were there any indications in the driveway as far as a vehicle, you know, were there any signs that a vehicle came to rest at that area?
There were, in the gravel, you could see where a vehicle had backed up and pulled forward. It was too big a gravel to get a tire track, a tread mark from it. But you could see that one had backed in there and then taken off, and it had spun just a little bit. So you could tell that it was consistent with what was reported.
Was there any damage on the property consisting with shots fired?
In the residence, we found, well, on the exterior of the residence, there was a bullet hole in the siding of the trailer going into the residence to where the bullet would have entered the residence. There was a hole in the wall, and then we found a lead bullet laying there on the side where it had hit, excuse me, the side of a gun safe that was there, and it come to rest, its final rest, right there on the carpet and on the side of it.
And was that collected?
Yes, sir.
As far as potential victims, who was on scene when you arrived?
When I arrived on scene, there was Mr. Weaver, junior, senior, the wife, his other son, I can't recall his name. There were 7 people on scene when I was there.
Okay. And then, was anybody injured?
No, sir.
Okay.
Getting back to the bullets, there was another bullet that was located in the side of a tree, but we attempted to dig it out and couldn't recover it. But it was a fresh hole, and the bark was missing. So there was two bullets that we found up in there, and that was right in front of the house.
Okay, so that tree, would it have been between the house where these people were allegedly at and where the evidence of shell casings were at?
Where the vehicle was parked, their driveway went around, and the house was parallel to the road, and that tree was between where the vehicle was parked and where the residence is at.
Okay. How were you able to develop a suspect in this case?
That night, they advised that there was 2 people that was identified as, they didn't know who they were. The following Monday, when I went out there, the store had allowed them to see the video, and they were able to put a name on Mr. Ragsdale.
Okay. Now, were you able to view this video?
I was able to get it that following Monday. Yes, sir.
Okay. Now, you heard Mr. Weaver's testimony concerning the incident at, is it Tuffy's?
Tuffy's Market.
Yeah, okay.
Yes, sir.
That's how I know it. Tuffy's Market near the Bon Aqua-Dixon line?
Yes, sir.
Okay. You were able to view that video?
We didn't see it that night. There was another employee, and he didn't know how to operate the camera, so the following Mondays when we were able to get it when the manager was present.
But you said the victim had seen it in between
Sometime over that weekend, yes, sir.
Okay. Were you able to collect it and preserve it?
Yes, sir. I do have a copy of it.
And were you able to eventually view it?
Yes, sir.
What did you see on the video?
On the video, it shows actually Mr. Ragsdale's in the store, Mr. Weaver's in the store. The video, they're not in there together making contact with each other. They're just both paying customers that go up to the register. It shows when Mr. Weaver goes outside and the altercation out in the parking lot. Mr. Weaver gets some paper towels and appears, it's consistent with the story that he's trying to get Mr. Ragsdale to clean the spit off the vehicle. And then there's Mr. Weaver swings his bat and hits the side view mirror on the truck, and then they all get in their vehicles and just drive off.
Okay. Were you able to end up, like, the whole spit and blood, why is that even, why is that relevant to this case?
Several weeks prior to that incident taking place, Mr. Ragsdale accidentally shot himself. He shot himself in I believe in the lower chin. I think he lost a couple teeth and the bullet came out. So he still had gauze in his mouth and he was bleeding from that. That would have put the blood in the loogie that ended up on the driver's side door window.
Okay. Are you able to make out Mr. Ragsdale in the video?
When he's at the register, yes. And then the same clothing, you can see him out going towards the vehicle that he's sitting in.
Are you able to positively identify him to that video?
At the store, yes.
Do you see that person here in the courtroom?
There's Mr. Ragsdale right there in the red shirt.
Did you eventually make contact with Mr. Ragsdale?
I did not have contact with him until we took him into custody.
Did he still have injuries from that gunshot wound? Or?
Yes, he still had gauze on his face.
Did he say anything?
Just that he didn't have anything to do with it.
Okay. All right. That's all I have, Judge.
Mr. McGowan, you may cross-examine.
Yes, sir, I am.
And his mouth at the time of the gas station incident, it was wired shut. It had.
I don't believe so.
You don't think so?
He's shaking his head no, so I'm going to agree with him no.
All right.
He was talking.
What's that?
He was talking when I talked to him on Monday, or whatever day it was. I spoke with him in person when we served the warrants.
That's how you remember it, right?
That's how.
You remember him talking with no type of impediment at all?
Correct.
Okay. All right. And did he end up, this interview, was that after he got arrested?
Oh, yeah, it was while we were serving the warrant, yes.
Oh, okay, okay.
He was Mirandized, and then I asked him a couple questions, and it was.
But you don't remember him having any problem at the time?
Speaking?
Yeah, speaking.
No, sir.
Okay. And briefly, the video that you watched from the store, he never got out of the vehicle, did he?
Yes,
Well,
he was in there was video of him in the, go ahead.
Let me rephrase that. That was kind of vague. After he exited the vehicle and got back into his truck, and Mr. Weaver approached his truck, he never got out of the vehicle at the gas station again.
After he was in the store and went back to the vehicle, no, sir, he did not get back out of the vehicle.
Other than the alleged spitting, the only person that on the video that seems to be
in the video
is the victim in this case.
In the video, he is seen walking over to the driver's side window of the van.
Okay.
And then he gets back into his vehicle. It's a distance where you cannot see the spit, but later it was recovered off the window.
So was that spit saved? I mean, there's a DNA swab.
Yes, sir.
Have y'all sent that off for testing?
It's been sent off. I'm sure they're done with it by now, maybe. I'll have to check on that.
And you said that there was a slug that was recovered from inside the trailer.
Yes, sir.
And that was saved in evidence.
Yes.
And that's been sent off for ballistic
It's
evidence.
been sent off, but it was too damaged to get anything from it.
And was that the complete slug, or was that shrapnel from a?
It was the lead portion of the slug, and it was damaged to where they couldn't even tell what the caliber was.
And you said there was another gunshot strike inside the trailer, or?
Inside of a tree.
Inside of a tree.
Yes, sir.
So we have one in a tree, a strike in a tree, and a
Yes.
strike in the trailer.
Yes.
Find any others?
No, sir.
And how many shell casings did you find?
20.
How many?
20.
You found 20 shell casings
Yes,
at the scene?
Yes, sir.
Okay. And only 2 strikes?
Yes, sir.
And then it's your understanding that only one person was out in the front yard that could possibly identify people?
I was told that Mr. Weaver Jr. was on the front porch and Mr. Weaver Sr. was standing in the driveway. And I told you how the drive swoops around. You could see directly down to where the gate is from where his truck was parked. And he said he was at his tailgate of the truck when the incident began.
Well, Mr. Weaver Jr. never identified any specific individual, did he?
He identified the truck.
He identified the
as the
truck.
same truck from the.
Now, has Mr. Weaver Sr. identified any specific individual?
He identified Mr. Ragsdale.
Was that in a photo lineup?
It was on a lineup with me. It was on where the gas station allowed them to go look at the video over the weekend. And that's where I think they took a picture with their cell phone.
So the victim went and conducted an investigation at the gas station, looked at the photo at the gas station, and then you were informed that he knows
they allowed him to look at
who
the
it
video.
was and where they live.
Yes, somewhat in that order, yes, sir.
And did he tell you who it was that told him the identity of the?
It was a female that they ran with. I don't remember.
You know her name?
I'm sure it's in my report. Maybe I think it's on Mr. Weaver Sr.'s written statement.
Now, there's been some testimony, and you heard this testimony. I know this has been an issue. You heard testimony from Mr. Weaver Jr. that he doesn't know Cody Ragsdale. This is the first time. October 20th was the first time that he'd ever seen him. In his understanding, you hear him say that. Did you hear Mr. Weaver Jr. say that?
Yes, I heard him say that.
Okay. And has your investigation revealed that that might not necessarily be true?
There was, from what I understand, there was maybe some type of an altercation that somewhere in the past years ago. And that was just hearsay what I've heard.
But you didn't get that information from Mr. Weaver Jr. or Mr. Weaver Sr. or anyone from his family?
No, I think I got that from Cody.
From who?
Cody Ragsdale.
All right. And that altercation was what he described to you as an aggravated robbery. Something was taken from him at gunpoint, correct?
Yes. Well, not gunpoint. I think there was a taser involved.
Now, have you asked the Weavers about that?
Yes.
Okay. And they just denied that?
Yes.
And have they given you any kind of reasonable answer as to how it was that Mr. Ragsdale would know him and how he would know where he lived?
No, the area, they're both their residents are probably within a mile of each other. They probably frequent at Tuffy's. I don't know.
Or Mr. Ragsdale doesn't live within a mile of the Weavers, does he?
By the way, crow flies probably pretty close to it.
How about now? Does he live there, close there now?
I don't know where Mr. Ragsdale lives now.
Okay. You know who he lives with?
I have no idea. He was living with his father at the time.
Haven't been keeping an eye on him?
No, sir.
Okay. Ballistics on the, there's been several guns recovered in all
Yes.
this. All right. Has the ballistics from any slug that was found inside the house or possibly in a tree, you just saw the strike in the tree, correct?
Yes.
So you only got one slug from the house?
Correct.
Partial slug?
Correct.
Has that matched in any gun that's been associated with?
The one that was recovered could not be identified. They don't actually use ballistics. They use the cartridges, the strike of how the hammer falls on the cartridges, and the bullets that were recovered and the two weapons I got, they're not matches.
Okay. They did not match?
No.
So any gun that has been associated with Mr. Ragsdale?
If you say any gun, the two guns that I was given, there's multiple guns and videos that I've never been allowed to see.
Multiple guns and videos. So there's the video from the bowling alley, correct?
Yes.
No, we don't have any video from the bowling alley.
No,
I'm sorry.
Yeah, you're correct.
That wasn't a
You're-
trick question.
You're correct, right.
All right. There's the statement that he had a gun at the video. There's a statement that he had a gun at the bowling alley, correct?
Right.
And then at some point, we don't know how long, later that night, he's pulled over on a traffic stop.
Correct.
And there's a gun recovered.
Correct.
Now, did any of the shell casings in the house match that gun?
Different caliber, from what I understand.
So you didn't, so no need to even test it, correct?
It wasn't my case, so I,
Okay. Well, that would help your case, would it not?
when I found out it was not the same caliber, there was no reason for me to go any farther with it.
And then, said the same guns in the video. There's no video from the trailer. They told you they didn't have any cameras, correct?
Correct.
And so there was, I guess, at some point, he was arrested on the warrant, and there were some guns seized from his house.
2 guns were given me from his house, yes. His father gave me 2.
Did he give those to you, or?
His father did, yes.
His father did, okay. Is that when he was being arrested, or?
Same day, yes,
Was that part of an investigation leading?
Same day.
Same day, okay. And those 2 guns, are you saying don't match?
The strikes from those 2 guns do not match the strikes on the evidence that was picked up from the driveway.
No further questions.
Redirect. Thank you. Detective, you may step down. State have any other proof? State has rested their case on the motion. Mr. McGowan, do you have any proof you wish to offer?
I was going to ask him about
You want to put him on for that limited purpose, I'll allow it. All right. Bring your client around. Mr. Ragsdale, come forward, raise your right hand, let's place you under oath.
and I'll keep it very limited. Mr. Ragsdale, what is your physical address right now? Where do you live?
1159.
And who lives there with you at that residence?
My dad, and then my baby mama and kid.
Okay, and you said a kid. You're a kid?
Sir.
Does your dad have a significant other that lives there?
No.
Okay. And how old is your child?
She'll be 1 coming in March.
Okay. And do you work?
Yes, sir.
Do you provide support, financial support for help
Yes.
pay the bills, pay the
Yes.
groceries?
Yes.
Okay. And where do you work?
Sam George Construction, LLC.
How often do you work?
Well, now lately, the past couple months, we ain't been working that much. He's still trying to find jobs to do.
All right.
This company's only been open a couple years.
But it's construction work, is that right?
Yes, sir.
And that's been a little slow during the winter?
Yes, sir.
Slower than what it is in the summer?
Yeah.
So were you busy this summer working?
Oh, yeah.
Okay. Is where you live now, is that within a mile of where these other folks live?
I assume so. South Bear Creek's right down the road.
Okay, so that's where you were living at the time this has happened?
Yes, sir.
No further questions.
Mr. Brooks, you have any questions on that issue? Thank you, Mr. Ragsdale. You may step down. Mr. McGowan, you have any other witnesses? State have any rebuttal proof? I'll hear you in argument.
Quickly, Judge, he was cited for simple possession. In September of 2024, he picks up these warrants for a shooting that had occurred, where there's compelling evidence that one did occur, and then he was one of the people that participated in said shooting. That happened in October 2024. And then the subsequent year, 2025, in February, there's another incident at the bowling alley where he is recklessly showing off firearms, placing people in fear. And that's corroborated by the subsequent contact with police where he just utters, is this about the incident at Thunder Alley? So he shows knowledge of what he's being stopped for right then and there. And then a subsequent firearm was located on his person. He has a trouble in abiding by the conditions of his release, and he is a danger to the community.
Mr. McGowan?
Your Honor, I know this is not a trial, and I'm not going to belabor and argue credibility of witnesses and or lack of any kind of factual evidence. I know my client is wrong because he was apparently had a firearm, which he wasn't charged with, by the way, and he wasn't charged with the DUI. He was charged with simple possession and paraphernalia, and that's the indictment before this court. But I think there's some problems with the evidence in this case. I think there's going to be a lot of investigation that needs to be done. My client is young, but he is a father. He needs to be working. He lives with his dad. It's concerning to me. I didn't realize that they lived that close to one another. But I think the bonds conditions can be amended to at least an extent to require maybe GPS monitoring or maybe even require him to live in a different place with his significant other and his small child. But he needs to be out working, and this bond condition or motion to revoke bond, I don't think was filed until October of 2025. The Thunder Alley happened in February of 2025, and then the original incident was in October 2024. And he's been to court. Can't tell you how many times he's been to court, but this is the first time that he's actually sat down in front of a judge, and we've actually taken proof. I think he understands. I think his record on bond reflects that he can abide by conditions of the bond without it being revoked and him sitting in jail. Thank you.
Well, I would disagree with that last statement, Mr. McGowan, respectfully, because you say that his record on bond indicates the condition. The original charge was a possession charge and misdemeanors, and then he's been charged with the shooting incident, which is the much more serious situation because that involves reckless endangerment, aggravated assault, and so forth. And those are felonies. And then more concerning is this one, the docket number 2025 CR 82 from the February incident at Thunder Alley, where he has now been charged with aggravated assault, 2 counts of that, as well as the violation of the order of protection and resisting arrest. So the violation of the order of protection is certainly an indication that he is not likely to continue to abide by the terms of any kind of bond condition. Tennessee Code Annotated 4011 141 subsection D provides that if after the defendant is released upon a personal recognizance, an unsecured personal appearance bond or any other bond approved by the court, the defendant violates the condition of a release, is charged with an offense committed during the defendant's release, or engages in conduct which results in obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond in order that the defendant be held without bail pending the trial or without release during trial. And this court's opinion, based on the proof that has been offered to me, we're very lucky that there's not a homicide involved in this case. I suppose one thing I could say is that we're lucky that there's such bad shots 20 shots that were fired, and only 2 struck some sort of an object. Those shots may have been intended to be not strike an object, but the fact that one of those shots went through a trailer and lodged inside the dwelling place is of great concern to the court, because it could have struck and killed a child, it could have struck and killed an individual. In any event, the more important thing is that the proof before the court today is that this Mr. Ragsdale didn't learn his lesson from being arrested on those charges, and was aware of the fact that he had multiple aggravated assault charges pending, and still went into Thunder Alley, an area that serves alcohol on a regular basis, and demonstrated that he carried a weapon on his person. And the only reason to show that weapon was to threaten someone. And as a result of that, it is this court's opinion that the evidence has established that under 40-11-141, his bond should be revoked. So I'll revoke his bond and order that he be held pending. I agree that he's a father. He should be working. He should be doing all of those things. He shouldn't be doing what he's charged with. Shouldn't be carrying a weapon around to a place like that and showing other individuals. And the proof so far, at least by the standard I'm required to on this hearing, is that he did in fact engage in that conduct. So this court revokes his bond and orders that he be. Does he have a trial date yet? All right. Then I will let you set it with Judge Wallace. So. All right. So this next court date is February 11th. We're going to take some other matters out of order.
All right, Ashley, if you do me a favor and make a note of that February 11th date, I think this is worth following up on. So I made a list as we were going of all of the pertinent facts of this case. And just to summarize, and I've mentioned some of these already, but we had a bloody loogie, which kind of kicked this whole thing off. And it was bloody due to the fact that the defendant on a previous occasion had accidentally shot himself in the face. So that's cool. We had a reference to a sizable woman, specifically somebody saying, "I've never met a woman that big." We have firearms, a bowling alley, a mobile home, air humping, unpronounceable Spanish names, an accidental reference to Kool and the Gang with Getting Down on It. Quote, "Was that spit saved?" was actually uttered from a lawyer. We had 20 recovered shell cases, but only 2 strikes. So as the judge pointed out at the end, the dude was a horrible shot. And the defendant lives with his dad, his baby mama, and 1-year-old child, thus playing into my comments the pre-show yesterday, I believe it was, about strong men. Of which this person most certainly is not one. Okie dokie, friends. We have a little under an hour left. It is a half hour left. It is Friday. And what do we do on Fridays? We indulge in our guilty pleasure. That wonderful place in Ohio where justice is best served in a dank, cold basement, where the screams of the dead are still heard to this day, where the crimson-colored carpet screams of a Kubrick movie, where the lighting is stolen from Soviet-era offices, where the audio is horrible and the justice is probably equally as horrible. Let's go to Dungeon Court.
It's the way I heard to watch the video. I think it was handed to me earlier today.
All right. Let me tell you what I've got. Of course, we could do the 20th. That's a Tuesday. We do need lawyers here.
I'll take you up on that.
Okay, let's do the 20th. January 20th will be the next hearing. 10 o'clock for pre-trial.
Thank you, Judge.
State of Ohio versus Noah Moore. Case number CRA 25-540, CRC 25-2020.
He's trying to get them in the seat.
Need a plea, do you say you're guilty of it, or do you do? You want to let people get out of the way? It's going to be a fine. Suspended jail sentence. No, you go to school. Schedule your treatment. Judge, we're going to have a change of plea.
Okay.
The OVI, we're going to enter it guilty.
Is that correct, Mr. Moore?
It is.
How's the state want to proceed? You want to delay sentencing or go ahead and sentence them now on the OVI and take it since the felony will remain pending?
Well, Your Honor, we've gotten this certificate of completion. This kind of got out of order as far as how we generally proceed in these things. So this is from, where's this from, Cardinal?
White Light. He completed the detox program there.
The detox program.
Yes. Yes.
Okay, all right, so
He completed an OVA.
Yes.
I got you. Okay, so now he's at Cardinal. Well, we're obviously encouraged by the progress he's made at this point. We would be, since we have this felony pending also, we would be willing to continue it and allow him to continue in treatment. We wouldn't take a position on the sentencing on the OVI today or delaying it. Either one would be okay with us.
Let's delay it. Let's see what, you're just getting started. Let's kind of wait and see how you do. Down the road, I'm going to sentence you on the OVI. So I'll accept the plea. Delay sentencing. Better you do on your treatment, the better I'll do on your sentencing on the OVI. So I want to encourage you to make a life change. And we want you to be successful, and to do that, I think you've got to basically turn over a new leaf and dedicate yourself to it. And once I'm convinced that's happened, then I want to help you be successful and not looking for any kind of punishment. Supportive services for you. So I appreciate it. Me that that's what's happening, that you're changing over to a new way of doing business. So let's come back and say a month or so, monitor how you're doing with your treatment. Okay. So February, Mr. Morford.
I'm pretty good, especially on the Fridays, but Mondays are doable too, Judge.
Okay. Well, we've got another one of those Tuesday dates. Can you do that, 17th?
Yes, Your Honor.
2/17 will be the next hearing. And it'll be preliminary hearing and sentencing.
You got these things? I got it. We got it. Yeah, I got it. Thank you, Your Honor.
You're welcome. Keep working, sir. Thanks.
State of Ohio versus William Spalding. Case number CRB 25-601, CRB 23-512.
Approach, Your Honor.
Yes. We have some application. Yeah, I need to think that. So continuance of your request. Yes. A couple weeks ago. Yeah, the 23rd is 2 weeks. This is in compliance with the custodial Okay, the state's asking for more time. There's been a video that's furnished by the alleged victim, but they can't open it, so they're going to get with them and see if they can't do something to get it usable. So, 2 weeks for that, I'll grant that to the 23rd of January. Will be the next one, January 23rd for pre-trial.
Thank you, Your Honor.
You're welcome.
Stateville High versus Angela Spurlock. Case number CRB 181327. CRB 181297. CRB 18558.
Mr. Morgan's case.
Judge, she's working on her community service at the present time.
And I haven't paid her too.
Okay. You're making a payment on fines today?
Yes.
How much?
Just $20.
Okay.
I have a question though. When I finish my community service, I can still do it to pay on my fines, correct?
Correct.
Okay. I just want to make sure.
All right, so we've been putting this on the sentencing docket, I think, because she has a bond up now, so this is what we do with under the bond. All right, see the clerk, make your payment, keep working on your community service.
Okay.
Let's go about a month out, February the 9th. Is that good?
Yes, Your Honor.
February 9th will be her next hearing. It will be sentencing.
Thank you, Your Honor.
You're welcome. See the clerk.
You're welcome. Here, take it.
State of Ohio versus Angela Pruitt, case number CRA 25623.
Since you work this case, could you call Antoine here?
May I approach you?
Yes. She's at Bethesda. Very good report, so you're actually helping other people there too, besides yourself, so good screens, good job.
Thank you.
Judge, when I can, I'd like to address you with respect to the treatment. She's wanting the court to okay her to go to outpatient treatment. Her father is ill with a terminal cancer diagnosis and is not expected to be with us much longer.
Well, I'm okay with it, but I'm not going to order it. I mean, I don't order the treatment providers to give any particular treatment. I let them decide what the treatment is. Now, if they come to me and say, well, we're not really sure what to do here, then maybe I would make a decision then, but I don't get that here. So I don't think they're recommending outpatient.
This is the first I've heard of it, so it would have to go in front of the clinical directors, and then several people have to be brought in before we make a decision.
All right, so here's what you need to do. I'm not going to order to go to outpatient. I'm going to order to get a treatment, and you're in inpatient right now. So you can discuss it with the folks there, and if you're unhappy about it, I guess you can bring it back. But my usual procedure is going to be to follow what the treatment providers recommend. So I don't get involved and tell the providers, oh, you should make them do this, you should make them do that, don't make them do this. I let them come up with a treatment plan, and then I enforce it. So I'm sorry about your circumstances, but if I did this, everybody would want out of inpatient. You understand? Everybody. Because everybody can come up with a reason they don't need to be an inpatient, they need to be outpatient. Almost. There are a few that say I need inpatient. But for the most part, people want the least restrictive treatment that they can get, which means them going home. So I'm not going to do that.
Okay. Permission to speak, Your Honor?
Well, you can, but that's going to be my ruling, so.
Okay. I don't have an issue with Bethesda. They're great. They're wonderful. I've accomplished a lot of things since I've been there. I'm happy there. I have no complaints whatsoever. I just have a lot of outside things going on.
Everybody does.
I know. I understand.
Everybody has outside things.
I understand that.
But here's the thing,
And also-
you're charged with a felony.
Absolutely. What is it?
You're charged with a felony.
Yes.
That means you could go to prison.
Absolutely. I understand
So this is a great opportunity for you. That other stuff, I understand it's a problem and for your family or whatever, but it's not going to change the treatment regime.
Okay.
Talk to the treatment provider. Don't come in here and ask me to order them to do something. I'm not going to do that.
I didn't mean it like that. I
Okay,
was
ma'am, I've heard you.
just- Okay.
That's enough.
Okay.
That's my ruling. February the 9th will be your next hearing.
Thank you, Your Honor.
State of Ohio recalls Christina Nisley, case number CRB 25567.
This is Mr. Smith's case.
Is Tyler Nigel here? Come on up. So do you have protection?
No. We got this next, that last, very first hearing.
Follow through, make sure she completes it and everything. Right. I don't know if it's a good, definite completion. We just want to make sure everything's okay. Your career's not have a definite completion date, or just be. It's probably continuous. Well, this way there for a second.
And it's got my diagnosis and like my medicine and stuff on there too.
Okay.
Yeah, she's got my.
Well, I understand that too.
Yeah.
I'd like to see what that report says. So, Your Honor, from all reports that we've gotten, including from Mr. Nisley, she's doing very well, and we want her to continue to do really well. And this is one of those ones that might not be able to be clear as to what the end date, what the success date is for this, but we'd like to get another report anyway to make sure that she's on her way to maintaining. So we'd like to come back one more time.
And Judge, I think that's appropriate, and I will get a copy of the court file for Mr. Hill for that report. She just had the one, but that's yours to keep in the court file. I agree, come back in about a month, and I'll ask Shawnee to give a letter. Is this going to be something continuous, lifelong, and there's no hard end date, but we'll have a better handle next time.
What's your schedule in February?
I'm here the 6th, 9th, or 13th.
Let's do the 6th. Mine's pretty busy.
Okay. February 6th, that works.
Pre-trial 10 o'clock.
Thank you, Judge. State of Ohio versus Robert H. Mayer, case number CRB 22-244A and D, and TRD 06-2492.
Your Honor, he's in the VA hospital right now with his wife. He had a heart attack last night.
This is, he doesn't have a lawyer. This is an old case. He has a bond out there, I think, doesn't he?
Yeah, I think so. Yeah.
He's where?
At the VA hospital.
So you're asking for continuance?
Yes, please.
How, do you have any idea how long he's
I
going to
have
be?
no idea. I couldn't tell you.
All right, and it's your request. I'm going to set it for January 26th. Now that's a Monday. Monday, January 26th will be the next hearing
At 10?
at 10 a.m. That's the VA hospital in Huntington?
Yes.
And you say he had a heart attack?
Yes, ma'am. Yes, sir.
All right. Hope he recovers well. January 26th will be his next hearing.
All right, thank you.
You're welcome.
State of Ohio versus Jason Hash, case number CRA 25-826. Your Honor, he has been picked up by Medina County.
All right, this is a Rule 4 to Medina County. Mr. Hash has been picked up by them, so the case here is dismissed.
Your Honor, we're ready to call some inmates.
Okay, we have some things to do at the jail by teleconference. We're here. Oh, we're here, okay, we're here.
State of Ohio versus Roger Pritchard, case number CRB 2617.
Roger Pritchard. All right, you're Roger Pritchard, correct? Mr. Pritchard, I'm Judge Capper. This is your, what's called an arraignment hearing. So first I want to tell you about your rights, make sure you understand. You have a right to remain silent. You don't have to say anything in this hearing. If you do make statements that what you're saying is all being recorded, it could be used against you to make some statement that implicates yourself in this situation. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, make the state will hire prove the charge against you beyond a reasonable doubt. And I think that's it. That's the right you have. Do you understand those rights, sir? I'm going to go over the charge with you that you were just handed a copy of. It's called the domestic violence charge. And it alleges that at Perry Township on January the 8th of 26, you knowingly caused or tried to cause physical harm to Rebecca Pritchard. And that Rebecca is either a member of your family or lives in your household. So that's why it's called domestic violence. Do you understand that charge? Any questions before you enter a plea to this charge? What plea do you wish to enter? You want a lawyer appointed to represent you? Do you have a job? Do you have any income? No? Social Security, what do you get? Yes. Okay, so you only work odd jobs? Roger Smith. Not guilty plea is entered for you. Mr. Smith's going to be the lawyer. Is 17 Private Drive, 187, Apartment B, South Point, your correct address? Do you have, if you were released from jail, would you have a place to live other than with Rebecca? Yes. Where would that be? She lived locally? No, she was Jackson. Okay, Jackson County. Mr. Hill.
Well, Your Honor, we've spoken with Rebecca, and Rebecca wants Roger back home, and she wants him to do anger management counseling. So she didn't want a protection order. So if he wanted to do anger management counseling, it'd probably go a long way. Oh, and apparently he's had a history of some drug issues as well, so she would like to have an SUD assessment and counseling. And under those circumstances, we would agree to an OR bond.
Okay. I'm going to let you sign the $1,500 signature bond. That means you just sign a piece of paper that says, I promise I'll come to court. As long as you do, you don't have to pay the $1,500. If you don't show up, then you'll owe the $1,500 and you get a warrant. So yeah, you can go back home. She didn't want you ordered to stay away, so you can go back home. What the state's saying, and you can talk to Mr. Smith about this, they want you to get some counseling. And they want you to assess for substance use issues too, so. You don't need this. Probably best is to talk to your lawyer about this, because the things you say in the courtroom, they can be used against you. What you tell him in private can't be used against you. What do you think? Well, I think we said something for you the 26th. January 26th. The next hearing will be a pretrial.
Yeah, that's easy.
At 10 o'clock.
That's the 4 lanes. You have to go like that. Easy. Too bad they didn't win last night.
There's no protection.
They didn't win last night. I did ask him, I didn't catch why he said that.
State of Ohio versus Logan T. Wright. Case number CRB 24.
Well, friends, we've reached that time where we have to call it a week. But it's been a good week, all in all. Thank you, Michael, for guest hosting earlier this week. Appreciated that. The days I was in the chair, I thought we had some good court. I know you had some great court on your day. So it was good. So good that we're going to add an hour to this show. So starting Monday, 9 a.m. Eastern, 6 a.m. Pacific. Channel members, you get your pre-show a half an hour before that. Speaking of channel members, if you're not already and you're a channel member, if you're not a channel member, you should do it anyways, but especially if you're a channel member, go to the linked chat, the pinned chat rather, and go to the link in there, and that is a link to join the Discord server. If you're not already joined, do that. The importance of that will become clearer next week with the 4th hour. There's certain things that channel members will be able to do, but in order to access it, you're going to need to be able to get on the Discord. So do that if you haven't already. We should have some best ofs this weekend, assuming I can get them done. I'm pretty sure that I can. If not, we'll have some other things posting, but we'll have some stuff for you. But go have yourselves a great day. Enjoy your weekend. Be with the people that you love. Have fun. We've all earned it. And I'll see you all Monday. Take care. God bless.